distinguished delegates, commissioners, representatives of national human rights institutions, human rights defenders, ombuds offices, and partners from across the globe. Afio Maya, Taalofa, and welcome. We are gathered here today, both physically in London and virtually across the Commonwealth, for the Commonwealth Forum of National Human Rights Institution hybrid high-level dialogue on fulfilling a human rights mandate in the context of shrinking civic space. At this point in history, while the mandates of CFNHRI members to protect and promote human rights remain steadfast, the environment in which we operate is increasingly challenged. From restrictive legislation to digital threats to authoritarian trends in governance, civic space, the very oxygen of human rights work, is under pressure. In today's dialogue, we will examine trends in civic space across the Commonwealth, share best practices to navigate challenges, and discuss how we move forward as institutions and in partnerships to fulfill our human rights mandates. Today's event and the presence of staff from the Samoa Office of the Ombudsman would not have been possible without the support of the Foreign Commonwealth Development Office. We are incredibly grateful for the FCDO's support of our work as chair of the CFNHRI. It is now my honor to introduce Commonwealth Envoy for the FCDO, His Excellency John Virgo, to provide some opening remarks.
Good afternoon, everybody. Talofa lava and kia ora to you all. Very warm welcome to London. It doesn't feel like a warm day, I'm afraid, but even though the weather outside has taken a turn for the colder, the welcome is very warmly felt to all of you. It's a great pleasure to have this delegation here from the Office of the Ombudsman of Samoa. I'm very happy that you're able to visit London. We were very honoured to welcome you in the Foreign Office a couple of days ago. And I know from my colleagues that you had a very productive conversation on that occasion. As you mentioned, my name is John Virgo. I am the UK Envoy to the Commonwealth, based in the Foreign Commonwealth and Development Office here in London. And I was particularly keen to come to participate in this dialogue today and to welcome all of you. A very warm welcome also to everybody else in the room and those joining online from a very challenging set of time zones. So it's fantastic to have you joining. And let me also extend my thanks to the New Zealand High Commission for hosting today's event and for supporting this really valuable opportunity for dialogue and exchange between Commonwealth partners. As the UK's Commonwealth Envoy, I know that human rights, civic space, civil society participation is absolutely at the heart of the Commonwealth. It's central to the Commonwealth Charter, it's central to the values that we all share as a family, and it is increasingly under pressure around the world. So it's particularly useful to be having this conversation today. Samoa's leadership over the past year has been really impressive since you became the chair of the Commonwealth Forum of National Human Rights Institutions. Despite the challenges of limited resources, the Office of the Ombudsman has been a very active and successful chair, driving collaboration, strengthening governance structures, championing the importance of cross-regional capacity building. And I know that you have done really important work in finalising the forum's strategic plan, convening the steering committee, taking steps towards legal registration. This is very much and deeply appreciated by partners across the Commonwealth. So today's dialogue on fulfilling a human rights mandate in the context of shrinking civic space could not be more timely and appropriate. Around the world, we are seeing increased pressure on civic freedoms, and the work of national human rights institutions it is absolutely critical in this context. Independent, well-supported national human rights institutions play an absolutely central role in safeguarding democratic values, protecting communities, and ensuring that human rights commitments are upheld in practice. The UK remains very committed to supporting this work across the Commonwealth and in the Pacific in particular. We recognise the vital role that NHRIs play in strengthening democratic resilience, in advancing gender equality, and addressing our shared challenges around climate change, environmental change. And we also welcome the ongoing conversations that are taking place around peer support and mentoring across the Commonwealth. We very much applaud Samoa for helping to champion that cause. So I'd like to conclude by wishing you very productive and inspiring discussion this afternoon. I wish you onward travel later this week to Geneva for the Global Alliance of National Human Rights Institutions. And of course, I know that you will be joining us in Antigua and Barbuda later this year as we gather as a whole Commonwealth family for the Commonwealth Heads of Government meeting. And I look forward to seeing you all on that occasion. Thank you all very much.
Thank you very much, Your Excellency, for your opening remarks, and again for the FCDO's continued support. I know that we are in London, and we are extremely 9,866 miles away from Samoa. But we take our culture with us wherever we go. In the Samoan way, we express our gratitude through gift giving. As such, please accept this small gift from Samoa as a humble token of appreciation for taking the time to join us here today. I now invite the CFNHRI Chair and Acting Ombudsman of the Office of Ombudsman and NHRI of Samoa, Ms. Langafuaina Tawita, to provide her opening remarks.
Aftailina, Excellency, distinguished colleagues, partners, and friends. Good afternoon, and welcome to the CFNHRI high-level dialogue on fulfilling a human rights mandate in the context of shrinking civic space. It is a pleasure to gather with you here at the New Zealand High Commission, and I want to thank all of you for making the time to join us, both in person and online. Across the Commonwealth, we are witnessing a moment of profound challenge. Civic space, the space that allows individuals and organizations to speak, assemble, organize, and participate freely in public life, is under increasing pressure. Restrictive laws, regulatory barriers, digital surveillance, and threats to media freedom are reshaping the environments in which our institutions operate. And these pressures affect not only civil society and journalists, but also the ability of national human rights institutions, ombudsmen, and public defenders to carry out their mandates effectively and independently. This dialogue is an opportunity for us to take stock of these trends, to learn from one another, and to reflect on how we can strengthen our collective response. We have brought together an exceptional group of speakers and facilitators, experts in civic space, digital rights, media freedom, and NHRI resilience. And I want to thank each and every one of them for their willingness to share their insights with us today. Our aim is not simply to describe the challenges, but to identify practical strategies, opportunities for collaboration, and ways to reinforce the independence and effectiveness of our institutions. Throughout the afternoon, we will hear examples of innovation, leadership, and courage from across the Commonwealth. Examples that remind us that even in restrictive environments, NHRIs continue to play a vital role in protecting rights and upholding democratic values. Today's dialogue also marks the beginning of a broader process. The discussions we have here will inform the development of a CFNHRI statement on civic freedoms, a statement that will guide our advocacy in the months ahead, including our engagements in Geneva and ultimately the formal adoption process at the biennial conference in Antigua later this year. So your contributions today are essential to shaping that collective voice. I want to thank the Foreign Commonwealth Development Office for supporting our office to lead this high-level dialogue. I especially want to thank Mr. Daniel Garlick, Deputy High Commissioner of the British High Commission in Appeal, for all his efforts in helping us put together this event from the start. I want to thank the New Zealand High Commission for hosting us and to acknowledge the support of our partners who have helped to make this dialogue possible. I thank our members and our stakeholders. Your commitment, your expertise, and your leadership continue to strengthen this forum and the work we can do together. With that, I look forward to a very thoughtful, honest, and constructive dialogue today.
Thank you, Lala, for those remarks. Before we move to our next segment, we'd like to capture a memory of everyone gathered here, both in this room and online. For those online, please turn on your cameras now. For our friends in the room, please face the screen at the end of the room. On the count of 3. I'm just giving you instructions. Don't worry. Our online friends, those who are participating online, please turn on your cameras. On 3, give us your best smiles. 1, 2, 3. All right. Thank you, everyone. I am now delighted to introduce our first speaker, Mr. Andrew Furman. Andrew is the editor-in-chief of Civicus, where he leads research on global civil society trends and the political, economic, and social changes impacting civil society. As a lead author of the Civicus State of Civil Society Report 2025, Andrew brings significant expertise to this dialogue on how global shifts impact our ability to protect fundamental freedoms. Andrew will provide us with a briefing on civic space trends across Commonwealth, grounding our discussions in the latest data from the Civicus Monitor. Please join me in welcoming Andrew.
Hi, everyone, and thanks for the invitation from set of initials, CFNHRI. Did I get that right? All right, so thank you. I'm going to just try and briefly present a little about, from the perspective of Civicus, that's the Global Civil Society Alliance. We have members in most countries of the world, including, I think, most countries of the Commonwealth. We're headquartered in Johannesburg, South Africa, and we have staff based all over the world, including a very small number here in the UK. And I'm going to present from our latest findings from the Civicus Monitor about the state of civic space. So when we talk about civic space at Civicus, we're talking about the extent to which 3 core civic freedoms are respected. That's the freedom of association, the freedom of expression, and the freedom of peaceful assembly. And the extent to which states uphold their duties, which they all have under international law, to protect those freedoms. And we're presenting research from the Civicus Monitor, which is our collaborative research project, which we've run for several years now. And with this, we work with around 20 partner civil society organizations all around the world. I'll spare you the methodological conversation, but we crunch a whole bunch of primary and secondary data, and we assign a country's civic space conditions on a rating system that goes from a 5-point system that goes from open, the best rating, through narrowed, obstructed, repressed, to closed, the worst rating. And year on year, the picture is not good. Year on year, the picture is, as you might expect, it's one of steady decline. So every year we see more countries moving into the more serious categories of civic space restrictions. It's never a unilinear trend. There are always some moving in the opposite direction, but generally the direction of travel is towards increasing repression around the world. I'm going to speak a little bit about global trends, and then a few specifically about what we see happening around Commonwealth countries. Globally, as it stands, only just over 3% of the world's population now live in countries where civic space is classed as open. That's where those key freedoms, association, expression, assembly, are broadly respected. People broadly have access to those rights. In contrast, around 73% of the world's population now live in countries where civic space is seriously repressed, where to try to exercise those rights is dangerous. Almost 31% of the world's population live in countries now in the worst category, closed civic space. So that, as I say, year on decline. Now we want to look at the nature of the tactics of restrictions and the type of activity that gets restricted. First, the nature of the restrictions, I think, fall into two main camps. There's restrictions that target organizations, that target civil society organizations. We're the Global Civil Society Alliance. I'm going to talk about civil society, but you can read everything I say as also applying to media organizations. Wherever civil society organizations are repressed, media organizations and journalists are also repressed. So in terms of organizational restrictions, there's an increasing amount of laws being passed that restrict associational freedoms, make it harder for people to organize and sustain civil society organizations. There's a particular contagion at the moment of foreign agents laws, laws that stigmatize civil society when it receives international funding as being the agent of another power. We're seeing a lot of these around the world, Russia-style laws that are increasingly being adopted, and that seems to have sped up in the last couple of years. Perhaps the more intense growth of restrictions that we're seeing are, and this is something that's really happened and really noticeable in the last few years, are restrictions that try to increase the personal costs of activism, that seek to directly place more costs on individuals, threaten people. We've seen a lot of restrictions that are around detention. We check our top 10 restrictions every year. Detention of journalists, human rights defenders, activists, those are the top restrictions we're seeing globally over the last couple of years, and then violence. So the other top restrictions are to do with excessive force towards protests, violence towards journalists. These are the main categories of restrictions we're seeing that are about increasing the individual cost of speaking out, of taking action, of organizing. Now, if you look at the kind of activities that most attract restriction, demands for democracy, where democratic freedoms are denied and where elections don't have reality and don't have substance. Demands for economic change. You'll be aware over the last couple of years, there's been a surge of Gen Z-led protests in many countries that have fundamentally economic motivations that are to do with youth unemployment and corruption and poor public services. So activity which seeks some kind of redistribution of economic power attracts restrictions. Demands for women's and LGBTQI+ people's rights, a particular challenge in some Commonwealth contexts. These are the hard cases that meet the most restrictions. So it may be the case that in some countries there are safer forms of activism, but as soon as you make demands for women's and LGBTQI+ people's rights, there's more of a backlash. This is seen as the more controversial areas. And then particularly around activity on corruption, activity on climate, the environment, land rights. And more recently, we've seen a lot of pushback by states against protests, particularly climate protests and particularly protests in solidarity with Palestine. So these are some of the peaks that we're seeing over the last couple of years. Turning to the Commonwealth. I mean, the interesting thing is the picture for the Commonwealth countries on the whole is a little better than the global picture. And that comes in the many small island states that are members of the Commonwealth in the Caribbean and of course in the Pacific. I think this is an under-researched area that we haven't really dug into or tried to understand. Something about the civic space dynamics of small states that may be more open, that may be less restrictive. This is perhaps something that we need to research further. But of the Commonwealth countries, 28 of them are classed as having serious civic space restrictions, being closed, repressed, or obstructed. One is called Eswatini. There are many more countries, particularly in Africa and Asia, that are in these serious categories. More happily, 13 Commonwealth countries are classed as having open civic space. I say mostly Caribbean and Pacific Islands. The biggest restrictions around the Commonwealth in the last year were around freedom of expression. So about 40% of all restrictions we tracked in the year in the Commonwealth countries limit freedom of expression. So that's for civil society and media. And then if you look at the top detentions, they're to do with the detention of protesters, the detention of human rights defenders, and the use of excessive force against protesters. Those are the big three when you look around Commonwealth countries. So looking at some of the causes of this restriction around Commonwealth countries, I think there's a cluster around the denial of democracy. We saw last year and early this year, non-competitive elections in several Commonwealth countries. One thinks of Cameroon, Tanzania, Uganda, and intense restriction around those elections, around those non-competitive elections. Intense and often violent restriction ahead of elections and then after elections as the state, as the often old presidents who needed to stay in control, needed to control the narrative and suppress dissent. We've seen a lot of repression of protest rights, as I mentioned, hotspots around climate protests and protests in solidarity with Palestine, including here in the UK, where the police are getting increasing powers to criminalise protests. Australia is another hotspot where at the state level, there are some now very restrictive anti-protest laws. I mentioned there's a particular challenge around civil society speaking out for LGBTQI+ rights in several countries in Africa, including Kenya and Uganda. And there's also challenges around the Gen Z protest movement in Kenya, and also around climate and environmental activism. One thinks of the suppression of activism around the ECOP pipeline development in Uganda. So these are some of the particular challenges we're seeing in Commonwealth countries right now. I want to end on some brighter notes. For civicers, although we have to say it like it is, that's our job. We also have to have a level of hope and optimism, because hope and optimism is what motivates everybody in civil society, because we believe the world is capable of change. So there's some bright spots around the Commonwealth in the last year. One thinks of the fact that Bangladesh has just held its first credible and legitimate election in almost 2 decades as a direct result of the Gen Z-led protest that forced out a deeply authoritarian and repressive regime. A bright spot. We've seen in South Africa some really strong climate activism, which has halted offshore drilling. We've seen in the success of climate activism in the Pacific with the court case that the government of Vanuatu successfully brought to the International Court of Justice last year, which says explicitly that states have a duty to protect their citizens against climate harm. That's a civil society victory. That started with a group of students in a Pacific students fighting climate change. I think they're called a group of Pacific students got together explicitly to try to get governments to adopt this agenda to make the International Court of Justice Act. And it was a great success. So that's a great civil society victory. And then we're also increasingly celebrating civil society's work in the Caribbean around the decriminalisation of homosexuality in many countries which retain colonial era laws. And in several Caribbean countries in the last few years, we've seen successful court victories that have achieved decriminalisation. So civil society around the Commonwealth, even in restricted conditions, is still trying to work, still winning some victories, isn't giving up the fight, and there's still hope. And I want to leave, that message of hope is really important. Now, we'll leave it there. That's a lot to cover. I think I bombarded you with a lot of percentages and stats, but I'm around all afternoon if there's any follow-up questions. Thank you.
Sorry, Lava. Thank you very much, Andrew. And on behalf of the CFNHRI, I extend our sincerest gratitude to you for kicking off today's dialogue. Thank you for framing the challenges to our human rights mandate with such clarity. Please accept this small gift as a token of appreciation. Thank you. It's now time for our first panel session of the day. Before I do introduce our first panel, if I can kindly invite our keynote speakers and also Mr. Andrew Fairman to make their way to the main table. Ole, please. Thank you.
Rubbish with me.
Thank you.
Right, okay. No, that's all right. I mean, I didn't. It's basically the same thing as in the school.
All right. Our first panel will consider the legal and regulatory challenges to civic freedoms. To guide this critical discussion, I am delighted to introduce our facilitator, Sneh Aurora. Sneh is the director of the Commonwealth Human Rights Initiative, or CHRI. Sneh is a distinguished human rights specialist with extensive experience in policy, planning and strategy development, international advocacy, and human rights education. Recently, Sneh has been instrumental in the publication of the report, Who Controls the Narrative? Freedom of Expression in the Commonwealth, a joint effort between the CHRI, Commonwealth Lawyers Association, and the Commonwealth Journalists Association. Please, ladies and gentlemen, join me in welcoming Sneh Aurora to the floor.
Hello, Falafa. And good afternoon, and thank you very much, Almeida, for that kind introduction. So, yeah, we've heard from some amazing speakers this morning, some things that we need to reflect on. And I just wanted to also say that indeed these are very challenging times. In fact, we were reflecting just yesterday at a panel hosted by Kaleidoscope Trust and the Malta High Commission, where it was noted that even describing the current moment as challenging or complicated feels like a vast understatement. What we are witnessing across many contexts is a broader pattern of democratic backsliding. And this is not only about individual laws or isolated measures, but it's about a wider shift. Institutional checks and balances are weakening. Independent institutions, including courts and oversight bodies, are facing mounting pressure. And the space for dissent, for scrutiny, for public participation is narrowing. So in this context, the use of law becomes particularly significant. Laws are no longer just instruments of governance, but they are increasingly being used to manage public discourse, shape narratives, and limit accountability. And this is why discussions like the one we're having this afternoon really matter. Because the question is not only how civic space is being restricted, but how institutions, including national human rights institutions, civil society, and legal actors, continue to uphold standards, push back where necessary, and maintain a principled engagement with states. So we have 1 hour for this panel, this panel discussion, and then I'm going to open up the floor for some questions from all of you in the room and also online. So please have your questions ready. We want to have this to be a active debate, not just we want to hear from you. So this first panel focuses on a question that is becoming increasingly urgent across the Commonwealth and beyond, how laws designed at least in principle to regulate and protect are being used in practice to restrict civic space. I wish to mention, if I may boldly here plug one of our publications. You might have seen this or received this recently. This is our recent joint report from the Commonwealth Human Rights Initiative, as well as our partners, the Commonwealth Lawyers Association and the Commonwealth Journalists Association. Who controls the narrative? Legal restrictions on freedom of expression in the Commonwealth. And this report documents this trend that we're going to be talking about today in great detail. The report reveals that laws are increasingly being used to manage, to control, to undermine, and sometimes silence dissent. And I'm sure the colleagues from CLA on the screen, who's joining us virtually, and from the Commonwealth Journalists Association in the next panel will discuss a little bit more detail the findings from this report. So coming back to this first panel, we will examine how laws have been applied in ways that make it harder for civil society, for non-governmental organizations, for journalists, and for human rights defenders, those who hold truth to power, to operate safely and effectively. The result is not always visible. It's not always visible as an outright closure of civic society space, but it's rather a gradual tightening. So you'll see we are faced with increased administrative burdens, legal uncertainty, self-censorship, and a growing risk of reprisals. And we'll be talking about this and hearing from our panelists a little bit more in these areas. And this is why the role of institutions represented here today, whether they are national human rights institutions, ombuds offices, and public defenders, is so critical. These institutions sit at the intersection of state authority and public accountability. They're uniquely placed to interpret laws, to challenge misuse, and ensure that legal frameworks align with human rights frameworks and standards. But they of course are also operating under pressure. They're often faced with the same legal and political constraints that aim to stifle civic voices. So this first panel, we will explore these issues to understand where the legal pressure points lie, how these laws are being used in practice, and also what can be done within existing mandates to respond effectively. And our distinguished panel, who represent a variety of regions as well as a variety of thematic issues, and include those from various institutions, from national institutions to digital experts and legal practitioners. And so without further ado, I'm going to introduce them to you. I want to invite firstly Pamela Tawala Sambo to the table, please. She is the chairperson of the Zambia National Human Rights Commission and an environmental law specialist in climate justice, environmental justice, and human rights. She's also a lecturer at the Faculty of Law at the University of Zambia, and she'll be speaking to the National Human Rights Institution's role within the wider ambit of civic and participatory freedoms. And with the advantage that we have of technology, joining online are our other three panelists. First, Lorraine Finlay is a human rights commissioner at the Australian Human Rights Commission. She leads the work of the commission in promoting and protecting fundamental rights and freedoms. She is a lawyer and an academic specializing in human rights and public law. There's also Shabnam Mojtahedi. Can't see her now, but there you go. She's a legal advisor for digital rights at the International Center for Nonprofit Law, based in Washington, and she provides technical assistance on how technology impacts civil space, freedom of expression, and privacy online. She's also worked with Benetech's Human Rights Program, leading efforts to apply artificial intelligence to human rights and war crimes investigations in Syria. And finally, last but not least, Sophie Stanbrook is co-chair of the Human Rights and Rule of Law Committee at the Commonwealth Lawyers Association. She's based in the Cayman Islands. She is the first president-elect of CLA, the Commonwealth Lawyers Association, and she also is the driving force behind the Women in Law movement in the Turks and Caicos Islands, which empowers and supports women in the legal profession. So a warm welcome to you all. So I'd like to begin, if I could, with Sophie from the Commonwealth Lawyers Association, who is, of course, joining us online. Sophie, you can hear us okay? Just checking the microphone as well.
I can.
Perfect. Welcome.
Yep.
So Sophie, from a legal perspective, we often see that the issue is not only about the existence of these laws, but also how they are interpreted and they are applied in practice. So drawing on your experience from the Commonwealth Lawyers Association, perhaps you could help us unpack this a little bit. What are some of the key legal trends that you are seeing across the Commonwealth jurisdictions, the use of laws to restrict civic space? And this could be new laws that are enacted, but also existing laws and how they are applied to suppress dissent and voices. And where do you see the most significant risks lie or shifts in how these laws are being applied? Over to you.
Well, thank you, Sneh, and thank you, CFNHRI, for convening us this morning. Talofa, and good afternoon from the Cayman Islands, where it's early morning. I'm sure I'm not the only lawyer in the room. However, I'm pretty sure that I'm probably the only one, or one of very few, whose day job is not in the human rights field. I'm a Caribbean transactional lawyer with English law roots, but I'm first and foremost a citizen of the world with a passion for rule of law and human rights. So looking at the lineup, and thank you, Sneh, for your introduction, I think my role is really setting the legal scene and giving you the lawyer's slant. And so for your sake, I hope I won't be too dry. So here we go. When lawyers talk about the legal regulation of civic space, we mean the whole ecosystem of rules and decisions that determines whether people can speak, organise and assemble without fear. It's the Constitution, yes, but also the everyday law of crime and regulation, the funding and licensing regimes that enable or disable organisations, and the choices made by police, prosecutors, regulators and courts. I think of it as both the architecture and the plumbing of public life. The grand design matters, but so do the joinery and the taps. How offences are drafted, how permits are issued, how long someone can be held before charge, and whether judges have the tools and the inclination to insist on precision and proportionality. So two countries can share identical rights clauses and yet produce very different civic realities. If one builds narrow, rights-respecting secondary laws and applies them even-handedly, while the other relies on vague offences and wide discretions that invite overreach. So if we step back and look at how this plays out in practice, you start to see some common patterns within the ecosystem. It's a very small family of legal tools that consistently shapes the boundaries of public discourse in our Commonwealth. And they do so through both new laws and through the reinterpretation of old ones. And I'll put my own plug in for the excellent report produced by CHRI, CJ and CLA, the Who Controls the Narrative, because I'm going to run through some highlights, but the report is 170 pages long and full of great information. So we have blasphemy or insult to religion laws, for example, which are not just about protecting belief. In reality, they often end up silencing minority views or anyone thinking differently. And where the penalties are very severe, even extending to death in some places, the effect is chilling. People self-censor, and it can even embolden vigilante behavior. We also still see criminal defamation and sedition on the books in a number of jurisdictions. Even if cases do not always end in conviction, the process itself can be enough. Investigations, arrests, court proceedings, that alone can deter journalists and activists from speaking out. And I know William Horsley will be speaking about that much more in the next panel. Then there is the newer wave of laws around cybercrime, false news, and online safety. These are often framed very broadly with quite sweeping powers. And the difficulty is that they can easily pull in perfectly legitimate speech, particularly on social media where expression is fast and informal. Counter-terrorism laws, these raise a similar issue. You know, of course, governments need tools to deal with real threats, but when the definitions are too wide or powers sit heavily with the executive, those same tools end up being used against peaceful protest or dissent. And finally, the rather insidious tool, as referenced by Andrew Firmin earlier, are the restrictions on foreign funding and NGO registration. These are usually presented as transparency or sovereignty measures. But in practice, they can make it extremely difficult for independent civil society to function at all. And it's often the smaller organisations, the ones doing the most grassroots, local, on-the-ground work that feel the impact most acutely. I was going to give you some sort of detail from the various parts of the Commonwealth, but I'm very conscious of the time. And so I would once again direct you to, take a look at who controls the narrative report, because it has a lot of information split out into different regions with examples and recommendations. And although the report speaks to, and on the face of it, it says freedom of expression, all of the legal tools that I've just mentioned are covered in the report, making it very relevant to this discussion. The common thread is not where this civic space narrowing happens, the locations, but it's how it happens. New laws are introduced under familiar banners: public safety, cybersecurity, counterterrorism, and those are all legitimate aims. But without clear definitions and strong judicial safeguards, those laws quietly expand the state's ability to regulate not just conduct, but speech and organisation. And at the same time, older laws are not disappearing. They are being reinterpreted and stretched to fit modern forms of expression, whether that's something said on social media or performed in a public space. So we have pressure coming from both directions, new powers being created and old ones being used in new ways, and the effect is cumulative. It creates a climate where people begin to self-censor, and that impact is not felt evenly. It is generally felt more heavily by minorities, dissenting voices, and those who are willing to question or scrutinise power. There are two other aspects in the legal framework to look at that impact on this and determine outcome. And one of them is the machinery around the laws. So it's licensing frameworks for broadcasters and newspapers. These can be applied neutrally, or they can be used to suspend outlets at sensitive moments. Permit systems for assemblies can facilitate safe protest, or can operate as veto points through onerous conditions and denials. Data protection and surveillance rules, access to information laws. Each of these choices raises or lowers the cost of dissent. And then we have the courts and the legal culture that supply the final variables in this picture, where judges insist on legality, necessity, and proportionality. Vague offences are read down and overbroad powers are trimmed. Where the judiciary defers reflexively, or where case backlogs mean justice delayed is justice denied, process becomes its own punishment. The independence of the legal profession and of oversight bodies counts here too. If lawyers fear contempt or regulatory reprisal for taking sensitive cases, and if national human rights institutions and media regulators cannot publish without favour or fear, the feedback loops that keep the system honest break down. The lived result of all this is a chilling effect that rarely announces itself in a single headline, as we know. Journalists start to self-censor because the cost of a complaint, even if baseless, is too high. Artists self-edit because the risk of offence is no longer reputational, but criminal. Community groups decline to speak at rallies because their registration or bank account might be at stake. And lawyers think twice before taking a brief that might anger a regulator or a minister. The public square narrows by increments, and the law, its text, its interpretation, and the enforcement have done the narrowing. There is a flip side, and it's important to say it out loud. Again, looking at some of the positive, the same ecosystem can be built to expand space. Repealing criminal defamation widens debate overnight. Drafting cyber and counter-terror laws with precise, conduct-focused definitions and strong judicial safeguards protects both safety and speech. Designing funding rules that are transparent but not punitive allows small organisations to thrive. Training police and prosecutors to apply necessity and proportionality at the charging stage keeps peaceful expression out of the dock. And equipping courts and oversight bodies to test government claims on evidence in public creates the habits that sustain openness beyond any one election cycle. In short, legal regulation of civic space is not a single statute or a single institution. It's a system of interlocking choices that either welcome scrutiny and participation or deter them. Understanding that system and the specific levers that most often shrink the public square is the first step to changing it. The good news is that we have tools that can be used by human rights institutions and others, and I would highlight three in particular. One is we have the Commonwealth Principles on freedom of expression and the role of media in good governance, which was adopted by the heads of government at CHOGM in Samoa, and which can serve as a checklist for human rights institutions. And we also have the Latimer House Principles, which together are a great compass for any human rights institution looking to do work in this space. Secondly, we have the extensive report, Who Controls the Narrative, which provides practical, global and specific recommendations. And thirdly, and this is my personal, one of my personal thoughts as I was doing the research into this panel this morning, is when it comes specifically to the making of laws, certain Commonwealth jurisdictions have already implemented procedures to make lawmaking more rights-proof, the actual making of laws, so not old laws that are already in existence, but when new laws are being proposed. And one strategy really stood out to me, which is the rights compatibility gate for any measure that limits civic space on security or public safety grounds. It would be, in the vein of the compatibility statement that is required for new laws in the United Kingdom. So this is the published statement of human rights compatibility from a sponsoring minister before the bill is put to before a bill is put to Parliament. I believe there's something similar in Australia and Canada, and I think we have Australia online. And I'm aware that in the UK, again, I found a great article, read it, and then I've lost it and I can't find it again. I was trying just before this session, but it spoke of the fact that during the last 20 years, there have only been 3 occasions that the UK has had to issue a statement of non-compatibility. And the effect of that is really, one of the great effects of that is to instigate greater parliamentary and public scrutiny of whatever that particular law is that is being proposed. It raises a massive red flag. So turning to regional collaboration, regional collaboration turns all of these mechanics into momentum, and the partnerships that we have make reforms stick. Looking at our panels for the rest of today, I see ICNL's Digital Rights Toolkit equipped human rights institutions to address online harms without criminalizing legitimate speech. And human right CHRI's Commonwealth-wide research provides the evidence base for proportionality analysis. UNESCO and the Commonwealth Journalists Association can help track media freedom impacts and design independent regulator safeguards that accord with the Commonwealth media principles. Within the legal family, CLA can mobilize bar associations and law societies to do at least, I can think of 3 things that they could do with you. We can help co-draft model clauses and templates, for example, for compatibility notes, drawing on Commonwealth precedents. We can convene rapid pro bono panels. We can support human rights institutions in strategic engagement with parliaments and courts, including amicus briefs that anchor the least restrictive means test in domestic doctrine. These are practical ways to live up to Latimer House principles and to defend the independence of the legal profession and judiciary. So let me end where I began. Civic space lives or dies in the details of law and how it's used. The legal families that most often shrink the public square are well known, and the methods, new texts and old reinterpretations, are familiar. Our task is to change the default by working together, using the tools we already have and asking governments to honour the standards that they have endorsed in spirit and in law. So I'll stop there and look forward to the discussion.
I'm sorry, you're on mute. Sorry, Sai.
Which is originally it's okay. The FCRA was originally intended to regulate foreign funding, but has increasingly been used to control and constrain the work of non-governmental organizations in that country. Then this has had a profound impact. Thousands of organizations, civil society, nonprofit organizations, have either lost their FCRA registration or have been unable to renew it, which means that they effectively are cut off from international or foreign aid, foreign donations. So as a result, many of these organizations have been forced to scale down their operations or have been forced to shut their doors altogether. Over 25,000 non-governmental organizations in the country have lost their license under the FCRA since 2014. And without access to foreign funds, they are unable to, they've ceased operations basically. This includes the India office of the Commonwealth Human Rights Initiative, my organization, where despite our ongoing court case, the government is using now the national legislation, national income tax legislation to silence us. And this has slowed down our operations in India significantly and unfortunately. So the case continues in court. I wanted to thank Sophie also for some hope, some positive recommendations on how, in particular, the CLA could support this situation and also to supporting non-national human rights institutions. It was very useful, Sophie, so thank you. I want to now shift gears a little bit. I'd like to turn now to Dr. Pamela Toela Sambo, Chair of the Zambia Human Rights Commission, and ask her to bring this discussion into a more practical institutional context, particularly from the Africa region. Across many Commonwealth African countries, constitutional protections are often undermined by broad exceptions, which are then reinforced through laws such as criminal defamation, sedition, and cybercrime. And these are exceptions particularly around national security, public order, and morality. In Zambia, for example, we will see this reflected in the use of criminal libel laws and media regulation to limit protest and restrict expression, particularly in sensitive political moments. And this becomes especially significant in the context of elections, where civic space, access to information, and public participation are all under heightened pressure. So, Pamela, my question to you as chair of the Zambia Human Rights Commission, how is the commission navigating its mandate to safeguard civic space and participatory freedoms, particularly in the lead up to elections? And in this context also, how are you approaching newer developments? I know you'll be speaking about the new access to information laws and your commission's oversight role in ensuring transparency and accountability. And I understand, Pamela, you have some slides with you for your presentation. I know that the people online, oh, we have them here as well. Great. The people online, you can see them as well, I am hoping. Yeah, great. Thank you.
Thank you very much, and a warm good morning, good afternoon, and good evening to everyone online and present with me here. I'm really happy to be with everyone, like minds together, and I'll give a practical perspective of how our National Human Rights Institution, the Zambia Human Rights Commission, is dealing with the globally shrinking civic space, but more so in particular to the upcoming elections in Zambia and the legal framework around it. So in terms of the presentation that I have, I'll just look very briefly at the Human Rights Commission and the legal mandate, the broad legal mandate that it has, as well as the legal framework that supports it. Then I'll move to looking at what I call the problem, and really it's just the shrinking civil space and what the Commission is able to do about it as the elections come. How are we looking at the legislation that we have, and generally how democratic is the space in Zambia, and what is the Human Rights Commission doing about it? So like all national human rights institutions, can push the slides to, thank you. So like all national human rights institutions, we rest our independence on the Paris Principles. And in line with the Paris Principles, the general framework is that the Commission must be independent. The National Human Rights Institution in Zambia is looked at as a fortress of independence. And how can this be achieved? The mandate is to promote and protect human rights for all within the country. And the Constitution specifically provides that throughout the Republic of Zambia, the National Human Rights Institution must look at the broad range of human rights that need to be guaranteed. Now, in terms of institutional strength, the Commission exhibits its independence on account of the freedom that it has to regulate its own internal reorganization, and there is no prescription in terms of any executive interference on what work the Human Rights Commission can do. Some of the direct action that the Commission does is investigating, and it has vested powers to manage and investigate human rights violations across the breadth, geographically and thematic-wise within the country. In terms of litigation, the Human Rights Commission Act of 2024 has since clothed the Human Rights Commission with power to have legislative personality. Previously, the Commission could not initiate litigation or participate in litigation because it had no legal personality. With this, it is expected that the Commission will be able to make strategic litigation cases in specific instances, especially those that cover a broad range of interests that the Commission deems to be affecting a wide section of the community. And because of this specific mandate with regard to the Access to Information Act, the Commission will combine the quasi-judicial function in the Access to Information Act, as well as the ability to undertake strategic litigation where there are abuses of a human rights nature. This is especially important in the upcoming elections because in the past, the Commission has only been able to make recommendations, and recommendations and advice are normally just that. So in terms of some of the serious violations that we'll be able to see as the election draws nearer, the Commission will be able to undertake strategic litigation and depend on the independence of the courts to make a decision that is going to be binding on whichever party is found to be wanting. The Commission is actively undertaking advocacy work as well, and this is especially helpful at the moment when the Commission is trying to bring to a stop issues to do with violence against women and which are coming out strongly within social media circles. While there are cyber laws that should curb such unwelcome behavior, especially towards the elections, most of the work is centered on how the men folk handle each other's affairs in the public sphere towards elections. So women have been a generally neglected group. What we have there being shown is one of our recent statements, I think touching on the Human Rights Commission work. It's a condemnation of some of the sexist remarks that have been going around in the media. And this is a statement we issued just last week because we already have a low participation level of women within the civic and political space in Zambia. So we're trying to see if this can be nipped in the bud to allow more women come forth in the elections that we're going to have this year. In terms of the key legal framework, when we come now to the specific issue of the civic space, we look to the Constitution, which the Commission also draws its mandate from. We also look at the Human Rights Commission Act, which I've already alluded to. And importantly, we have the Access to Information Act, which has given a new mandate to the Human Rights Commission of Zambia with the oversight mandate. So where information holders withhold information to requesters, the public has recourse to the Human Rights Commission. So far, we have one case that we have received on appeal. The commission is fully functional with regards to that mandate, but still requires a lot of support in terms of how to carry out some of the specific functions that are itemized in the legislation. When we come specifically to the civic space, we see that there's been an enactment of cyber laws, specifically two laws, the Cybersecurity Act, as well as the Cyber Crimes Act, both of which were enacted in 2025. With these two pieces of legislation specifically, there has been an ease within the civic space in terms of how political mobilization will come up, because these pieces of legislation have broadly defined offenses with using the cyberspace. This is coupled with what we are seeing as a debilitating effect of the Public Order Act, which has remained in force since 1955, has been amended along the lines, court pronouncements made in terms of having a more facilitative environment for political mobilization, but the practical effect is still that there is a restricted exercise of the rights to associate and assemble. I think on the next slide, I have a real focus in terms of what is the real problem? What are the key constraints when we look at the digital space? And because the digital space is a place for mobilization for most actors in the political space at the moment. So the problem is that the digital space as well as the physical space have been affected by the new legislation. The digital space, as I mentioned, by the 2 cyber laws, and the physical space is restrained because of the effect of the Public Order Act. And while the country has recorded gains, for instance, in recent years, the offense of defamation of the president has been outlawed, we have seen that the new legislation in the form of the cyber security and cyber crimes legislation are more or less reintroducing this offense, because a number of political actors have been charged on offenses that still mirror what we see in terms of the defamation of the president. And the net effect is that we see the impact of the legislation with some of the news headlines we have in the country, as I beam there, where some of the opposition political parties have been arrested. And there is also activism by civil society, notably the Law Association of Zambia, that has taken the case of the enactment of the Cyber Crimes Act to court. That matter is still pending in court. So civil society is also under pressure. When we move to the next slide, we see that there has been intimation about the non-governmental organization bill. This piece of proposed legislation also looks more at restriction than regulation when you look at the broad sweeping terminologies and powers of the registrar to cancel NGOs' licenses. When we now come to how human rights are infringed within the framework of these new pieces of legislation, it creates a lot of work for the National Human Rights Institution. And this is coupled with the oversight mandate that the Commission has, as I mentioned, under the Access to Information Act. How then do we, as a commission, operate within the boundaries of independence and advocacy that are required of us in order to protect the civic space? I think when we look at the Access to Information Act, this is a piece of legislation that is giving hope in terms of access to information by members of the public generally. And within this piece of legislation, the Commission is restricted to strict timeframes within which to make decisions on cases that are taken. We also look at the level of preparedness. I think I alluded to this already, that we have received 1 appeal so far, and this is a pending determination in order to be more facilitative of access to information as we get to the general elections. What is the way forward as a national human rights institution? I think in terms of, first of all, the facilitation of this meeting, the exchange of ideas, we need to be vigilant. We have already seen a lot of information globally has been gathered. We had this shared with us. Zambia is no exception. From the net effect of some of the new legislation that we are seeing, we see that there is a likelihood, a great likelihood, that the civic space in terms of how we pursue the elections in August this year may be shrunk. So we need to be vigilant. The key aspect of independence puts the National Human Rights Institution at a vantage point. And as a National Human Rights Institution, we intend to use this vigilance and independence as a way of spurring action together with other actors towards ensuring that there is need to defend constitutionalism, as well as ensure that there are no rights, or to the extent that rights are abrogated, there is remedy. When we look at how rights are being abrogated or likely to be abrogated in the name of security, we see that this is something that is already coming under play with how the Public Order Act is being enforced, We have been at several round tables trying to make sure that this changes before the forthcoming elections. And the Commission is already armed with what I have brought out as the strategic litigation mandate, that we can also still go back to court on that issue. Although the issue of the Public Order Act and its restrictive application has already been before court several times. So that also calls on how the Commission is going to think outside the box in terms of what other mechanisms are available, so that the Commission is truly a guardian of human rights for the citizens, particularly as we go into the election cycle. Closing thoughts. The Commission's legitimacy is defined by the practical effect of our independence. As we prepare to go into the election this year, we are calling upon our independence and collective courage to act. Many of the circumstances, we find that some of the issues have already been legislated upon, and even though the Commission may have been involved as a stakeholder in the commenting provisions before the bill is enacted, the thoughts and ideas that the Commission brings to the fore with regard to the preservation of human rights mostly are not taken on board. And the argument is that the Commission has been consulted. So we need to also see, I think, in terms of the contribution that the Commission makes from initiation of legislation right up to the final output that is given. Because at the final output, it becomes a little more challenging to undo a piece of legislation that has already taken effect. As a Commission also, we are glad that such opportunities as we have had and as we'll be having in the next few months to exchange ideas with like minds, to compare notes across the Commonwealth, they contribute to the collective protection of human rights, and we create a peer system that we use to benchmark what is happening in all the jurisdictions that we are looking at. So I think that is where I can end, and I'll end just by thanking you for your attention and support during this process. Thank you.
Thanks, Pamela, for those practical insights on how these challenges are playing out in Zambia in particular, and also with respect to in the context of the upcoming elections. I know we're running out of time and we started a little bit late, but I'm going to now just move right into the Pacific. So I would like to turn to Lorraine Finlay, Human Rights Commissioner at the Australian Human Rights Commission, who's joining us online. Lorraine, can you hear us okay? I'm hoping you can. I can see you.
And you can hear me okay?
Perfect. Yes, thank you.
Fantastic.
So building on what we've heard, I'd like to shift the focus slightly to broader institutional and systemic challenges, particularly in contexts where the legal protections for rights may be particularly well established, but pressures on civic space are emerging in more subtle and complex ways. So this includes the use of national security frameworks, regulation of protest, increasing challenges in the digital space, and perhaps you could speak to those issues. How are these evolving legal and policy challenges affecting civic space in Australia? And of course, what role can national human rights institutions, particularly from the perspective of the Australian Commission, play in ensuring that responses remain proportionate and consistent with human rights standards? Over to you.
Well, thank you so much, and thank you to the Commonwealth Forum and our Samoan colleagues for bringing us together for this really important dialogue. As was mentioned, my name's Lorraine Finlay. I'm Australia's Human Rights Commissioner, and I'm incredibly glad to be with you, although I do fear that my invitation has perhaps come because Australia is providing such a rich number of case examples at the moment in terms of shrinking civic space. And I must admit, that was presented starkly in Andrew's initial map that he showed us, which had Australia not in the deep green of open countries, but the slightly muted green of countries where there is that narrowing of civic space. And in Australia, I think we're very aware that while in some countries you see those constraints on civic freedoms almost emerging overnight, that's certainly not the case in Australia. And what we're seeing is these constraints really developing incrementally through legal and regulatory responses to legitimate public concerns around safety, social cohesion, national security and protection from harm. And I just wanted to touch on three particular issues where this tension is particularly visible, and then one other issue about the process through which this is occurring. And the three specific examples I wanted to mention from the Australian context were hate speech regulation, protest rights, and digital regulation, specifically being the Australian social media ban for under 16s. And then the process issue I wanted to touch on very briefly was the rushed lawmaking processes that we're seeing increasingly in Australia that are really affecting the ability for scrutiny and are affecting civic freedoms. In terms of hate speech regulation, I think it is quite apparent that in Australia, conversations around this topic have taken on a renewed urgency. And that's primarily because in recent years, like in too many other countries, we've really seen growing religious and racial hatred in a broad sense, but particularly stark in the context of the substantive and troubling rise in anti-Semitism. These absolutely are not abstract concerns or abstract trends, and they're not limited to words alone. And the anti-Semitic terrorist attack at Bondi Beach in December last year, which claimed the lives of 15 innocent people in the most awful of circumstances, was a really deeply confronting moment for Australians. And it brought into sharp focus the real-world consequences of extremist violence and the ways in which hatred can escalate into devastating harm. And what was really apparent to us was that this wasn't just an isolated act of violence, but that it was actually the culmination of years of rising anti-Semitism and rising hatred being seen in Australia through a variety of forms. And so against that backdrop, there's a genuine and legitimate case for strengthening legal protections against serious hate-based harm. And we all know, and I don't need to tell anybody in this room, that international human rights law clearly permits restrictions on expression where advocacy of hatred amounts to incitement to discrimination, hostility, or violence. But, and I'm referring to a point that Sophie made earlier, the critical question isn't simply whether the law should act, but it's how it does so that really matters. And recent law reform proposals and legal changes in Australia have highlighted the risks of getting that balance wrong, because we've seen laws being drafted in overly broad or imprecise terms, laws that collapse the distinction between hateful conduct on the one hand and offensive or controversial speech on the other, and potentially laws that rely too heavily on criminal sanctions, which ultimately risk actually doing more harm than good. And when legal thresholds are unclear, enforcement becomes unpredictable and lawful expression risks being chilled, including political debate, academic inquiry, journalism, and human rights advocacy. And there's also a deeper democratic risk to this, which is that free speech protections exist not to defend popular or comfortable ideas, but to allow us to have those difficult conversations, to allow contested and minority views to be aired, and to allow all of these things to be challenged in open democratic processes. And so when hate speech laws are sloppily drafted or when they're rushed through our legislative processes, they risk becoming really blunt instruments that undermine the very freedoms that we depend on to counter hatred in the longer term. So in my view, the task we have in Australia is to try to ensure that our legal responses to hatred are tightly drafted, are proportionate and are principled, and that they're squarely focused on preventing serious harm, which is an important, legitimate aim, but also preserving the space for open discussion, disagreement and dissent. I have no doubt that confronting hatred does require strong laws, but it also requires clarity and precision, and for those laws to be drafted with an enduring commitment to the fundamental freedoms that underpin them. And I think another area where those same pressures can be seen, and again, which was mentioned already by Andrew, is around the regulation of protest in Australia. And Andrew touched on both environmental activism and more recently, particularly pro-Palestinian protests as being two examples where the impetus for these new laws can be seen, and that's certainly the experience in Australia, acknowledging, of course, that the right to protest extends only to peaceful protest, and it has to be balanced with the rights of others. So governments do have a legitimate responsibility to protect public safety, public order, and critical infrastructure. And people are entitled to live free from violence, intimidation, and harassment. But how you can do that while at the same time preserving the space for protest that is so essential to any democratic society is really the question. And in Australia, what we've seen is the impetus for these restricted laws really arising from the fact that in the movements that Andrew spoke about, while many protesters have engaged peacefully and lawfully, there also have been a number of highly visible incidents where some conduct has crossed into intimidation, harassment, or the glorification of violence, and that's really driven the calls for stronger legal responses. But the way we respond to those challenges really matters, and the way we draft those laws matters, and the way we enforce those laws matters. And across several Australian jurisdictions, we've seen new criminal offences, significant increases in penalties, and expanded police powers. And while each individual measure, when it's been introduced, has been justified by reference to safety, the cumulative effect of these things has been a marked shift in terms of the overall approach to protests in Australia. And the risk is that laws that are designed initially to address specific harmful conduct are drafted and enforced in ways that allow them to begin to operate much more broadly, so that they capture peaceful protest and lawful dissent that actually poses no genuine threat to safety. And when those thresholds are lowered and that discretion is widened, the practical space for democratic participation necessarily narrows, often in ways that are really difficult to reverse. And I think that's the challenge that we're seeing play out here in Australia. So when I talk about the risks of these types of laws, I'm certainly not suggesting that protests should be beyond regulation. It shouldn't be. But it also needs to be recognised that it is a core democratic practice, and particularly for people whose voices are otherwise marginalised. So the challenge is to ensure that the law differentiates clearly between the right to peaceful assembly and conduct that's violent or intimidating, and that any restrictions on that right remain necessary, proportionate, and targeted. To shift gears just slightly, the third area I really wanted to highlight briefly is a digital environment, which we know is a space that is central to modern civic life, and particularly for young people. And I think Australia has rightly been recognised internationally for some of the leadership it's shown in online safety regulation. And I would imagine there would be no disagreement in the room that protecting children from online harm is a legitimate and important objective. But again, the way that we do this really matters. And in my view, the introduction of a blanket ban that we've seen in Australia on access to social media for children under the age of 16 really raises serious human rights and practical concerns, both for the rights of children and young people, but also for the general population in Australia. My view in relation to this particular legislative reform is that the outright ban is a really blunt instrument. It risks disproportionately limiting children's rights to freedom of expression, access to information, participation in social and cultural life, education and health. And for many young people, particularly those that are marginalised, online spaces provide really vital connection, support and civic voice. There are also a lot of unresolved questions in Australia around the implementation of this policy, privacy and effectiveness, because enforcing the ban requires age assurance measures that can normalise intrusive data collection and surveillance as a matter of law, and there's a real risk that harm will actually just be displaced rather than actually reduced. And more broadly, I think this debate reflects a real challenge that democratic societies face more broadly, which is how do we regulate digital spaces in ways that genuinely enhance safety without silencing voices or narrowing participation. And when you look at the social media ban, it is quite clear there are a range of responses that could be adopted, like greater platform accountability, safety by design approaches, or investing in digital literacy that would actually be more proportionate and rights-respecting alternatives compared to the blunt instrument of the ban. The final thing I just wanted to touch on really briefly is the process by which we're seeing these laws introduced, because a common thread running through these debates in Australia is not only what laws are being made, but how they're being made. Because we're seeing a growing tendency for significant rights-affecting reforms to be rushed through Parliament because of the urgency of the issue they're trying to address, with limited consultation and truncated scrutiny. And this was evidenced in the recent hate speech reform proposals that were advanced at speed in response to the understandable community concern and devastation following the Bondi terrorist attack, without sufficient time to test definitions, thresholds, and unintended consequences around what was really significant legislation. It was also evident in the passing of the social media minimum age laws, where, again, the process was markedly compressed. This legislation, which was world-leading legislation that hadn't been done anywhere else at this stage, was passed through the Parliament in a matter of days. The parliamentary inquiry considering the bill allowed the public 1 day for consultation, and they held a single public hearing lasting for just 3 hours, where expert stakeholders, children, young people, even our National Children's Commissioner weren't heard in terms of the impact that this legislation would have. And the reason that this matters is because process is a safeguard for substance. Robust consultation, evidence-based policy development, and parliamentary scrutiny aren't just bureaucratic obstacles, they're essential democratic checks. And when laws regulating civic freedoms are rushed, the risk of overreach increases, and public confidence in both the law and the institutions that make it is undermined. So the core message I wanted to leave you with today is that, in my view, good lawmaking processes are themselves a core component of protecting civic space. And to that end, national human rights institutions have a critical role to play in terms of scrutinising laws, amplifying the voices of affected communities, and insisting on restrictions on rights that are lawful, necessary, and proportionate. And that role is always going to be most effective when it's exercised in collaboration with one another through regional cooperation, peer learning, and the sharing of good practice. Which is why I'm so pleased to be here with you today for you, tonight for me, and I'm really looking forward to joining in the rest of the conversation on this panel. So thank you again for having me today.
Lorraine, and have some of those peaceful assembly and the digital environment. I'm going to move right into our fourth panelist, Shabnam Mojtahedi from the International Center for Not-for-Profit Law. So Shabnam, I want to ask you, building on what we have heard so far, I would like to focus more directly on the digital dimension of civic space. So in the report that I mentioned earlier, Who Controls the Narrative, we noted that there's a rapid expansion of laws and policies governing online spaces, often framed around cybersecurity, misinformation, or online harms, but with significant implications for freedom of expression, association, and access to information. I know that we're running out of time as well today, this afternoon, so I wonder if we can keep your intervention to about 6 minutes. I'm sorry, Shama. I know there's a lot to say. There's so much to unpack. in all of these presentations. But Shamla, maybe you could explain some of the global trends you are seeing, also trends within the Commonwealth in the regulation of digital civic space. And finally, if you might reflect on the role of national human rights institutions as well in responding to some of these new emerging challenges. Thanks very much.
Sure, thank you. Can you hear me okay? Okay, great. Thank you to CFNHRI and the organizers for the invitation. I wish I could be there in person, but glad that I'm still able to participate in this panel virtually. At ICNL, we focus on creating an enabling legal environment for civic space and civil society. My role specifically is to focus on the laws and technologies that impact digital civic space with a focus on the right to freedom of expression and the right to privacy. I was asked to speak about the trends on digital rights. I think I am able to keep my remarks a bit shorter because fellow panelists have already touched on many of the current trends. I hope I won't be repetitive in this regard, but I did want to talk a bit about cybercrime and both the risks created by cybercrime proliferation and also the laws that are seeking to regulate it. Cybercrime is estimated to have, in the year 2025, about a $10.5 trillion drain USD on the economy. So there's no doubt that there's a real and both the real and perceived threats create risks to access to information as people might be reluctant to engage online. Also, tech-facilitated sexual-based violence we've documented, has a chilling effect on freedom of expression and access to information. However, as other panelists have said, the way that cybercrime is being addressed through law could and has been creating greater risks instead of actually targeting the specific crimes that it's seeking to address by including overly broad restrictions on speech, as well as disproportionate surveillance powers that go beyond what is authorized usually in regular criminal procedure or penal laws in the country. Others have spoken about this, and I won't go too much in depth on it. However, I did want to note that the UN Convention on Cybercrime, which was adopted by the UN General Assembly and is in the process of being ratified by member states, could further entrench and incentivize abuses due to the fact that it does not include many of the safeguards and specific limitations that human rights defenders and advocates had been hoping would be included there. And so keeping note of how the implementation of the UN's Convention on Cybercrime moves forward, I think could impact in a great deal domestic practices and the push to collaborate across countries to share data has been characterized as a race to the bottom in terms of privacy rights. When we talk about laws, I know that that's the focus of this session, but with regards to technology, I do want to say that we are seeing increased sophistication of technology, often enabled with AI, and that a lot of these abuses are happening extra legally. We are seeing a proliferation of surveillance targeting civil society, civil society advocates, journalists, and other critics of governments, and that is having a huge chilling effect, as well as harming the psychology, I think, of the space, because people fear that they could be targeted by these technologies. And spyware, if you're not already aware, has a complete the complete ability to monitor devices and communications, regardless of existing encryption or other privacy protections on a device. So this technology is quite invasive. It is increasing in sophistication, and we are seeing that it's becoming increasingly difficult to employ traditional digital security techniques to mitigate those risks. And also with the sophistication of technologies, we are seeing governments restricting internet access and imposing content restrictions and filtering through new and more sophisticated technologies that again are more difficult to track, more difficult to document abuses, and more difficult to navigate and mitigate and circumvent that censorship. Third, I wanted to touch on the transfer of laws and technology from global North countries to global South countries. I think Lorraine spoke about this, the laws in Australia. We've seen similar type of laws in the UK that have a risk of being adopted wholesale in other countries around the world. Similar to what we saw with the GDPR and likely the AI Act, where putting aside the risks to human rights in Australia and the UK and other Commonwealth countries, when those laws are adopted in situations where there is a lack of there are rule of law gaps and existing weaknesses in existing legal systems, there is even more of a risk that these will restrict civic space and civil society. And also with regards to technologies, there is a big push for digitization of government, digital transformations, digital public infrastructure, whatever term you want to use. We're seeing that those technologies are then being transferred to the Global South under the rubric of protecting or improving access to government and services, whereas actually these technologies do increase the risk of data breaches in situations where there's weak cybersecurity protocols in place, and also the risk of surveillance when there aren't any safeguards to ensure that data cannot be unlawfully accessed by other departments and agencies of government. So we wanted to address all of these risks and connect NHRIs to the growing movement to address digital rights around the world. And I think that there is a great need in this moment, as civil society is facing increased pressures, that all the stakeholders who have the ability to influence these processes come together and are able to work together. And so that's really what we wanted to achieve as we're working increasingly with NHRIs. Specifically in Africa, we saw that there is a big gap of NHRIs and a gap in terms of their focus on digital rights and their capacity to do so. So we wanted to work with civil society organizations in Africa as well as NHRIs to try to address that gap. And we developed a toolkit that hopefully will be shared with you, the link, to address the specific considerations that NHRIs have in terms of their protect and promote mandate under the Paris Agreement, and to explain, what digital rights are, what are the international and regional norms, and the role of NHRIs in promoting and protecting digital rights, how digital rights monitoring is different from traditional human rights monitoring, what does the governance of internet and digital technology technologies look like and what are the different stakeholders and actors involved in that process, and then go through the types of laws and regulations that impact digital rights, including from network disruptions, internet shutdowns, vague or disproportionate online content restrictions, untargeted or invasive digital surveillance, and then provide specific links and resources and questions that NHRIs could be asking to address these issues domestically. So for example, under internet shutdowns, there are recommendations for NHRI's role in promoting human rights and digital rights by requesting the public disclosure of all agreements between internet service providers and the government, the ability to review the agreements to ascertain if and how the government is authorized to order an internet service provider to disrupt internet access, recommending to internet service providers that they provide notice to their customers whenever any government orders come in to shut down the internet or to disrupt networks. And advising the government on the civil, political, social, and economic impacts of disruptions, and under the protection framework to prepare, particularly in situations where elections are upcoming, to prepare to document and receive complaints about potential disruptions, and to meet with regional and local CSOs that are members of maybe global or regional or domestic coalitions, such as the Keep It On Coalition that is managed by Access Now, a global organization working on internet freedoms and internet access, and reviewing existing draft legislation for provisions that may authorize network disruptions, calling for revisions that better comply with human rights law. So those are just some examples of what is included in the toolkit, and we really hope that that they will provide a kind of a launching point so that NHRIs can start asking questions internally and adjusting kind of operations to address these issues more systematically. And we are hoping that we can work with NHRIs in the coming year to help them operationalize the toolkit and work with them more in depth. We are planning to do this in depth with 3 NHRIs as kind of a test case this year. We're very much hoping that the Zambian Commission will be one of the first organizations, the first NHRIs we work with, and we are very open to discussing this further with any other commission that is participating in this meeting and discussing how we can support your work further and connect NHRIs with the digital rights community. Thank you again. I hope I kept it short enough.
Thank you, Shabnam, for your thoughts on cybercrime and new technologies, and also sharing with us some practical resources that national institutions might be able to use in this space. It's a very emerging and very important area that we will, I'm sure, be debating further in the near future. So with that, I'm extremely sorry, we're running out of time. I've been told that we are not able to open up the floor for questions. I know that it's been an extremely vibrant discussion with our panelists, but if you have, for those online, if you have any questions, please write them in the chat and we will endeavor to respond to them after this session. And for those in the room, we're going to have a networking break at the end of this event tonight, and you'll be able to talk to our panelists who are in person at that time. So with that, I wish to thank all of the panelists for their insights this morning. Clearly, there's a lot more to discuss. 60 minutes or 70 minutes is not enough time. We've heard that restrictions on civic space are not always sudden and visible. They often take shape through gradual use and expansion of laws, but also at the same time, we've heard some really interesting good practices, and there's reason for hope. It does give us hope that with the tools and the resources and support, national institutions can work with and collaborate with others in this space to address some of these challenges that we're speaking with today. So thank you again for all of our excellent speakers, and I'll turn it over to our host.
All right, welcome back, everyone. We will now move on to our second panel session. which will discuss media freedoms and the safety of journalists, a topic that is critical to the health of any democracy. So to guide us through this complex landscape, I am delighted to introduce our facilitator, Dr. James Jirian Kanda. My apologies, sir, if I'm pronouncing your name wrongly.
That's fine.
Dr. James is a senior research fellow at the Institute of Commonwealth Studies and the School of Advanced Study at the University of London. He's a former editor of the Journal of Commonwealth and Comparative Politics and a contributor to the Annual Register, an expert on the politics of development and nationalism and religion in South Asia and the Middle East. He has published widely on these themes and taught at several UK universities for 3 decades. We are especially grateful for Dr. James' presence here today, not only for the wealth of experience he will bring to these discussions, but also for his very kind agreement to moderate the session at such very short notice. Dr. James, we now invite you to introduce your panel.
Thank you very much, and welcome back to this session. I should just start by saying that I will be perhaps a bit harsh in cutting the speakers short or at keeping them to time, because we have overrun quite a bit. So please excuse my rudeness at that point. Anyway, it gives me great pleasure to introduce our 3 panelists. The first speaker will be William Horsley, who is a colleague of mine at the Institute of Commonwealth Studies, also a senior research fellow there. He's on the executive committee of the Commonwealth Journalists Association, and I, of course, came across William, as many of you might have, as a long-time BBC journalist, and he played, in connection with today's discussion, he played a leading part in the adoption of the Commonwealth Principles on Freedom of Expression and the Role of the Media, which was adopted at the CHOGM in 2024. He's also an emeritus professor of journalism at the University of Sheffield. Our second speaker will be speaking online through a recorded message, and that will be Alafina Wuki, who is a lawyer and commissioner for the Fiji Human Rights and Anti-Discrimination Commission, and she's a human rights advocate with a particular focus on gender equality, workplace safety, and constitutional rights. And the third speaker will be John Bosco Muiga from UNESCO, who was part of the core team that coordinated the UN Plan of Action on Safety of Journalists and the issue of impunity. He previously worked with the UNDP in Rwanda and at the UNESCO Regional Office for Eastern Africa. So it gives me great pleasure to introduce the 3 of them. So the main questions that they will be addressing is how media freedom strengthens civic space, what are the main risks journalists face today, and of course we are all aware of the very large number of journalists who have lost their lives in recent years, in not only places of war like in Gaza, but also in places of supposed peace, including in the Commonwealth. And we will also be looking, and they will also be looking at how partnerships with media organizations can enhance advocacy of human rights. So without further ado, it gives me great pleasure to ask William to speak first on the role of the media in sustaining civic space.
Yes, sure. So, well, good afternoon, everybody. Thank you very much for this opportunity, and many thanks to everybody who's made this high-level dialogue possible. I've been very impressed by the substantial inputs we've heard from many experts. So yeah, I've titled my piece "Protecting Civic Engagement and Open Debate in the Context of the Media Principles," formerly the Commonwealth Principles on Freedom of Expression and the Role of the Media in Good Governance. That's the rule of law aspect of it. And of course, what we want to do is see how, with I think a cultural change, which is long overdue in the Commonwealth, I'll talk about that, this can help to empower civil society and prompt governments and parliaments to put in place the genuine protections for media workers, as well as human rights defenders and others exercising their fundamental freedom of expression rights. The media principles do actually cover Article 11. You can see independent oversight mechanisms. They mention human rights commissioners, ombudspersons, media regulators, election commissioners, and the principles, of course, now have the formal backing of governments. Many past statements and declarations have also had the backing of governments. And the central question I really want to put today is how to make these implemented and effective, because the Commonwealth's record is poor. My main message, I think, is it's time for a reset in that direction. It seems clear from today's input and what we know that the Commonwealth is struggling in the current constitutional setup to present a credible face as a champion of democratic rights and the rule of law, given the serial violations and collapse in all the areas that we've been discussing today. And what's needed is a much more open in contribution and engagement and partnership with international experts and Commonwealth stakeholders, which is the kind of thing that the Council of Europe, OSCE, and of course UNESCO have done. So we can discuss that later. It's a highly representative piece of work, the principles, with the Commonwealth lawyers, in addition to the Commonwealth journalists, it's the Commonwealth lawyers, legal educators, parliamentarians, Commonwealth Human Rights Initiative, and the Institute of Commonwealth Studies. We are keenly aware of the failure, effectively, of previous ambitious items, including the Commonwealth Charter, which spoke of answering a surge in popular demand for democracy, including the Commonwealth Human Rights Commissioner idea 15 years ago, which was sank by states that were not willing to be scrutinized, and of course the CMAG mandate of 2011, which expanded to include countering and sanctioning constraints on civil society and the media. They had little effect altogether. So the UN Action Plan, which John Bosco will be talking about, is another inspiration because, of course, it pointed to the way in which media workers in particular are at the forefront of confronting violations, and therefore they are at most at risk, and the statistics show it. So move to the next slide. You'll be familiar with these cases, the cases of Gauri Lankesh in India, in Bangalore, and Daphne Caruana Galizia in Malta. What these tell us, as do many other cases, is that the cases which occurred nearly 10 years ago still have a real impact on the people, the communities which were being served by the information from these journalists, the brave journalists. Gauri Lankesh, of course, standing up for minority rights against Hindu nationalism and indeed the Dalits, and Daphne Caruana Galizia, really for ordinary people in Malta who were living, as in Daphne's words, in a climate of fear if they challenged the stranglehold of two political parties and the network of slaps and public abuse, which she received eventually, of course, ending in her death in a remotely charged car bomb. In both cases, the masterminds and many of those perpetrators have not yet met justice. So that brings into question lots of things. Next slide, please. And this is just to illustrate. This is a vice president of the CJA. Shamal Datta, who is one of many journalists in Bangladesh, seen as sympathetic to the former regime of Sheikh Hasina, which was ousted, who has been subject to exclusion. He's been detained since August of last year and deprived of bail, deprived of his bank accounts, as are his family, and hopefully he will be one of the tens of the 15,000 or so groundless cases that were identified under the previous government. Next slide. So time is going to constrain what I go into, but here this is the Commonwealth accepting this basic premise that freedom of expression and media freedom are essential to give effect, in effect, to a wide range, all of other fundamental rights. But the main point I want to raise here is the language about the Commonwealth heads having agreed that the member states should take concrete and meaningful steps to implement the principles. Sadly, we've seen little or nothing of that, and I have to say that is despite very vigorous efforts, indeed what we saw as pledges before the adoption of these principles. That is to the point that speaks to the point that I made at the beginning of the need for some kind of cultural change and a reset. So let's look next slide at some of the key, what I see as the key elements. So Article 2 is, in effect, this is the sort of landmark item in the principles for the Commonwealth and perhaps the UK as the spawner of these colonial era laws, particularly on defamation, sedition and blasphemy, because the fact is, as the data has shown, and many lawyers and journalists from across the Commonwealth were involved in drawing this up, about 3/4 or more of all Commonwealth countries still have criminal sanctions in those areas, and international law says they should not be there. This is the kind of thing that parliaments, as well as I hope the International Parliamentary Union and the Commonwealth Parliamentary Association will take up, as Sophie Stambrook, I think, was saying. And there, of course, it's laws. It's not only those particular laws, but laws against slaps, abusive lawsuits, online abuse and harassment of children and women, and all the others, which has been much magnified, of course, by social media and the advent of artificial intelligence. So Article 7 is the key one about states having an obligation to put in place these prompt protections. Again, the language on that in these principles is less than what might be expected under international law. That, of course, is partly because of a revision process that took place in 2021 before the law ministers adopted these principles as part of this long and winding road. Article 8 goes to perhaps the most salient point in terms of the Commonwealth's justice systems, and the Commonwealth record is very poor, with a much higher, 10% higher rate of impunity for killings of journalists. There we have some statistics on the number of killings as well. So we can move through the next slide, which we're already familiar with this. Sneh spoke about the report, and go to number 7 to look at what the report tells us in some detail about the record of states. This is a mine of information, of course. So those statistics about the criminal laws, then the arbitrary application of laws, the Commonwealth in action. Many of the contributors to this from the stakeholders spoke about the Commonwealth's lack of engagement, despite their fine words, as a contributing factor, leaving them defenseless, and then the number of killed and the impunity. So next slide. Recommendations. Here are 5, but I hope in further dialogue we will go into these in more. First, I think, is a cultural one, as I mentioned, to end what I'm afraid many see as an effective taboo on monitoring and scrutiny as such of member states, which, as I suggested, has been repeatedly rebuffed by the member states. This relationship has to change if the Commonwealth is going to stand up for itself as a champion of the rule of law. It's just not good enough for it to be a club seen to be a club as leaders. And this is very damaging for the Commonwealth's reputation. This is not destructive criticism. This is essential if the Commonwealth is going to have a new life, a new lease of life in a much more demanding world. Then we have the criminal sanctions thing as it were the front end of this. The Commonwealth CMAG, Commonwealth Ministerial Action Group, needs to open up. Its statements on Tanzania and Bangladesh have touched on the subject, and of course the threat of further action. But it has to be a lot more dynamic and interactive. It has to reflect the realities that we've been discussing today. I think the only way to do that is to have the Secretariat act as a sorting office, act as a genuine, like it happens in UNESCO and the Council of Europe and so on, as an enabler. And then the question of oversight bodies, that including on some kind of a task force or an envoy of the Commonwealth, something of that kind needs to be done with the consent of member states, but also with pressure. And UNESCO, I think, it would be a very good partner in that direction. My final thing, if you move to the last slide, is we do have a lot of, I mean, the UK and Canada, as you know, set up the Media Freedom Coalition back in 2019, and there are 12 Commonwealth countries in that. Do they feel some kind of responsibility? That's what they say in their pledge. There are 2 points lifted from the pledge there, which they've all signed. I won't enumerate them. You can read it on screen. But I think my final point, I hope that all these things can contribute to the vital work of Commonwealth human rights national institutions. The reality that comes through this report when you read it is that while in many parts of Africa and South Asia, you see these constraints, pre-constraints in the law, the atmosphere of intimidation and reprisal, leading to self-censorship and basically denying ordinary people the diverse and independent information they need. But also many of the countries, I would mention Rwanda as one, where one of the contributors said simply that independent media is unthinkable, is impossible in today's Rwanda. And a country like India, where individual contributors described how the lack of any legal protection for protection for journalist sources and the ample use of sedition laws and anti-terrorism laws has put a pall over the work of journalists with a climate of intimidation. I hope this is all germane to later discussions. I look forward to it very much, and thank you for your attention.
Thank you very much, William, for that. And without any further delay, we will go on to the video message, I think, from Alafina Wuki, who is from the Commissioner for Fiji Human Rights.
Go. The Honorable Chair, distinguished delegates, and esteemed colleagues from the national human rights institutions and the ombudsman offices. Ladies and gentlemen, Bulavinaka, greetings from Fiji. And I am so sorry for not being able to be there with you at the panel discussion. Thank you for the invitation to share on the topic, National Human Rights Institutions and Ombudsman Offices Responding to Restrictions on Freedom of the Press, from the perspective of small island states. But I will mainly focus on Fiji's experience as a Pacific small island state on this subject matter. As you all know, a fundamental principle of the international human rights framework is that a free, independent, and robust media is essential to democratic governance, transparency, and the protection of human rights. In Fiji, its current situation on freedom of the press has significantly improved since 2022. According to Reporters Without Borders, its report on 2025 lists 4 Pacific Island countries in the top half of the rankings of 180 countries in relation to their media freedom levels. Of the 4 Pacific Island countries, Fiji performed the best in 2025, followed by Samoa, and after Samoa, Tonga, with PNG ranking well below these 3 Pacific Island states. Certainly, the change of government in Fiji in 2022 led to a positive impact on Fiji's media landscape. The 2022 Reporters Without Borders stated that Fiji was, and I quote, the worst place in the Pacific region for journalists, end of quote. And the report ranked Fiji in the 102 place out of 180 countries. That was in 2022. In 2023, Fiji progressed to the 89th place. In 2024, it moved further to the 44th place. And last year, in 2025, the Reporters Without Borders ranked it at the 40th place out of 180 countries. To understand how Fiji became the worst place in the Pacific region in 2022 in relation to media freedom, and the role of Fiji's National Human Rights Institution in Fiji in relation to this particular aspect, let me take you back to 2007. In 2007, our predecessor, the Fiji Human Rights Commission, as it was known then, engaged a Fiji-born consultant living in Hawaii, Dr. James Anthony, to review and report on the freedom and independence of the media in Fiji. The report heavily criticized the Fiji media for being biased and unprofessional. It argued that absolute press freedom was not appropriate for Fiji's social context, and that the media needed to be more responsible and balanced. the report shifted the focus from the freedom of the press to freely report on government's activities without fear or favor, to the rights of the government to regulate media reporting in the public or national interest for national stability. The report was rejected largely by the media in Fiji, and concerns were expressed by the media industry that the report opposed media freedom and was used by the Fiji Human Rights Commission to defend and support the December 2006 military coup. Certain sections of the media considered it scandalous that such a report should emerge from the Human Rights Commission, a public body that they rightfully said is responsible for defending the rights of all Fiji citizens. In spite of these concerns and criticisms by the media industry in Fiji, the Fiji Human Rights Commission approved and endorsed the Anthony report, recommending it to the then interim military government. The interim military government used the Anthony report, and by citing that the report came from the Fiji Human Rights Commission, presented its restrictive new media laws as being in alignment with human rights principles. The Fiji Human Rights Commission was seen as providing the intellectual and legal justification for these restrictive new media laws. The actions of the Fiji Human Rights Commission in commissioning and endorsing the Anthony report, which justified the 2006 military coup and the state censorship of the press, led to its suspension from the International Coordinating Committee for National Human Rights Institution and the Asia Pacific Forum in 2007. In May 2009, Fiji's 1997 constitution was abrogated by the then President Iloilo, which brought immediately into force public emergency regulations. Media censorship began immediately after the abrogation of the 1997 Constitution, and the public emergency regulations were used to arrest journalists. But by then, the loss of confidence in the Human Rights Commission meant that many chose not to make their complaints to the Commission. The military regime brought into being the Media Industry Development Decree 2010, which later renamed it as an act. This act brought to an end the tradition of media self-regulation, an essential component of a free media. The act imposed heavy fines and possible imprisonment for journalists, criminalizing what once was simply known as actions of ethics. Add to this political intimidation and harassment, and naturally, self-censorship became a media response to this hostile and repressive environment imposed by the military regime. In fact, this act created a pervasive climate of fear and self-censorship that lasted for well over a decade until its repeal in 2023. And what was the response of the suspended Fiji Human Rights Commission during this period when the military regime was actively enforcing the Media Industry Development Act 2010? Well, ideally, it should have examined this Media Act in light of its compatibility with international standards, particularly freedom of expression under Article 19 of the International Covenant on Civil and Political Rights and Article 19 of the Universal Declaration of Human Rights. In practice, however, the Fiji Human Rights Commission's role during this time was seen as too aligned with the ruling military regime and therefore was not independent. The Commission did not publicly challenge the restrictive and punitive aspects of the Media Industry Development Act 2010, and also it did not take a leading advocacy role in defending journalists or media outlets facing threats and punitive measures under the Act. The Commission was viewed as failing in its duty to defend freedom of expression when it was under heavy restrictions. In more recent years, the successor to the Fiji Human Rights Commission, the Fiji Human Rights and Anti-Discrimination Commission, has taken a more active role in advocating for rights and engaged more openly on issues such as freedom of expression and media freedom. In June 2021, the Fiji Human Rights and Anti-Discrimination Commission, thank God, was accredited with B status by the Global Alliance of National Human Rights Institutions. This accreditation strengthened the Commission's role to actively safeguard, protect, and promote freedom of expression and media freedom, including, of course, other fundamental freedoms as expressed in the Bill of Rights in the 2013 Fiji Constitution. So while the 2022 Reporters Without Borders reported Fiji as the worst place in the Pacific region for journalists, 2022 also brought an end to the long rule of former Prime Minister Frank Bainimarama. The coalition government under Prime Minister Mbuka repealed the draconian Media Industry Development Act 2010 in April 2023. The Fiji Human Rights and Anti-Discrimination Commission welcomed the repeal of the Media Act as it provided a critical opportunity to re-establish a genuinely free and independent media environment. The Commission continues to engage closely with the media industry, journalists, civil society organizations, and state agencies. Through consultations, roundtables, and public dialogue, we promote constructive engagement on the balance between media freedom, accountability, and access to information. The Commission emphasizes that freedom of expression by the media must be exercised responsibly with due regard for accuracy, fairness, and respect for the rights of others. For a core principle of the human rights framework is that no rights exists without responsibility. National human rights institutions are uniquely positioned to serve as independent guardians of fundamental freedoms. We are mandated to monitor developments affecting human rights, provide independent advice to governments, and promote the protection of fundamental freedoms, including freedom of expression. When restrictions on the media arise, national human rights institutions must respond through a principled, balanced, and rights-based approach grounded in constitutional guarantees and international human rights law. First, we must systematically monitor and document violations affecting journalists and media institutions. This includes arrests or intimidation of journalists, censorship of media outlets, misuse of laws to suppress reporting, and restrictions on media coverage during elections, protests, or conflicts. Second, restrictions must be assessed against international human rights standards. Under Article 19 of the International Covenant on Civil and Political Rights, any limitation must meet a strict three-part test. It must be prescribed by law, pursue a legitimate aim, such as national security or public order, and be necessary and proportionate in a democratic society. Equally important is the role of national human rights institutions in providing accessible complaint mechanisms so that journalists and media institutions can report intimidation, harassment, or unlawful interference. For Fiji, while the repeal of the Media Act 2010 is a significant move forward, yet the media environment in Fiji still face risks and challenges. Self-censorship still lingers. Harassment of journalists and photographers still persist, particularly when covering sensitive court cases, and online abuse is an emerging and growing phenomenon. In this regard, the Fiji Human Rights and Anti-Discrimination Commission will continue to monitor development, engage constructively with relevant stakeholders, and advocate for reforms that strengthen the legal and institutional framework governing media freedom in Fiji and grounded in human rights, international law. And on that note, I wish you all a successful and fruitful discussion. Vinakavakalevu, thank you, and God bless each and everyone.
Thank you very much for making those points at the end. Our next speaker is John Bosco Meiga, who is from UNESCO, and he'll be talking about the UNESCO's initiatives and especially also about related events that are taking place this year under the auspices of UNESCO. John, please.
Thank you so much. Good afternoon again. First of all, I would like to thank the organizers for having invited us to this meeting. I think it's important for us to be engaged in meetings like this because it allows us to network with critical institutions that promote part of what we do and we take full advantage of that. And I will also take the advantage of being here to announce a few of the things that we were planning to see if you could be interested, but we believe that you would be interested because it also falls within your mandates. National human rights institutions are very important for our work. And most recently, we've come to the strategic realization that while we have engaged very many duty bearers, particularly the judges, the prosecutors, the security forces in promoting press freedom, we have somehow not engaged adequately the National Human Rights Institutes, despite the fact that they have a very strong mandate on promoting human rights and by association, the freedom of expression and safety of journalists. So within the framework of the UN Plan of Action on Safety of Journalists and the issue of impunity, which UNESCO coordinates, we engage different stakeholders depending on their comparative advantage, and we work different networks and coalitions in order to promote this right. We work with, for example, groups of friends on safety of journalists and the issue of impunity, which are like member states-led process, the media freedom coalitions, probably some of those, UN Focal Points Network on safety of journalists, civil society organizations on safety of journalists, academic research, together with for example the University of Sheffield, where William works. So all these are different nodal points and institutions that we collaborate with in order to promote the implementation of the UN Plan of Action on safety of journalists. But I would also like to, before I go to the events that we're planning, I would also like to emphasize in addressing some of the questions that were framed as part of the discussion of this panel. Why media freedom is important for civic space. I think this is a very important question to internalize and also to respond to, because then we make the strong justification for why we should do the things that we actually do. But I mean, we can't claim that we answering the question at this point because it has already been answered from the founding documents, emphasizing the criticality and centrality of media freedom to the enjoyment of other human rights. For example, in General Comment number 21 of the International Covenant on Economic, Social, and Cultural Rights, it talks about how freedom of expression underpins the right to participate in cultural life, or centering if you're going to enjoy cultural life, and freedom of expression is important. General Comment number 34, which I guess many of us working on the area of freedom of expression are very familiar with, also talks about the interdependence of right of opinion, expression, and participation in public affairs, and all the other documents, including, for example, the Vienna Declaration and Plan of Action on Human Rights, which already set the argument and the premise that if other human rights are to be enjoyed, it's fundamental that freedom of expression and then freedom of the media are important in that equation. So, and for that reason, in 2023, the World Press Freedom Day, the theme was about shaping a future for human rights and emphasizing that centrality. And we did it purposely in order to show that it's important to safeguard this very important space because it is a driver of other human rights. So, given that sort of framing and premising of media freedom, so anything that then encroaches on that space should be a matter of concern to all of us working in this area. And I'm happy that one of the questions also framed is about the risk factors. What are the risk factors that journalists and media freedom is facing in this respect? Let me talk about the global trends, because I think this were mentioned at the very beginning of this dialogue, that are a bit worrying for some of us and other actors working in this respect. So you've probably come across different reports that point to the fact that there is a demonstrable global decline in democracy and media freedom. And when we say global decline, we are talking about the recession of civic space in relation to media freedom, not only for the countries or regions that were, previously known to be having that deficiency, but also in areas that were regarded to be democratic by all definitions. So last year, UNESCO published a major report called The World Trends on Freedom of Expression and Media Development, and it had some interesting statistics for our consideration. One of them was the statistics that freedom of expression index has declined by minus 10 percentage points since 2012, and they use some statistical methods of calculating this. But the significance of the minus 10 points is big. It's not a small percentage. It's quite a big percentage, and this is a global decline. It also indicates that self-censorship has risen up to 63% since 2012. I think the issue of self-censorship was already been discussed by previous speakers. This is very concerning because besides the pressures that different institutions bear on media workers and journalists, but the idea that they have to silence themselves in order to not make ends meet, in order to survive in different situations, is worrying. And 63% is quite a big number. And also more concerning is that governments have intensified efforts to control and restrict media by 48% since 2012. And this speaks to the pressures that come to the media through different forms of power, including governments. But these statistics are not isolated because they also kind of vindicated by other research. For example, the IDEA research on the state of democracy that you probably know about, that came out last year, and the others, the VDEM research, which came out most recently. The moderator is telling me that I have 2 minutes, so I'm going to keep it very close. I think the disadvantage when you speak last is either there's too much time left and then you can make use of that, or there's very little time and then you don't have time to finish. So anyway, so having said that sort of background, I would like to say that human rights institutes, as far as we are concerned, are an important factor in our work, and we would like to emphasize the issue of strengthening monitoring and reporting at the national level, because this allows us to validate the data, because we're working at a global level. Once we have data at the national level, it creates a validation process that is easier for us to create, talking points, if I may call it, or advocacy issues related to the work. But when we have global data that can't be validated at the national level, it's very difficult. And the issues of press freedom and freedom of expression are very, very rare or minimal in national human rights reports. This is something that we would like to encourage you to, we can partner on to work on. So let me speak about the World Press Freedom Day then, finally. As you may know, UNESCO every 3rd of May organizes this important event, which is the biggest global gathering to celebrate the World Press Freedom Day, but also to look at the issues and factors that are affecting media freedom. This edition is coming at a time when so much is going on in the world, as we've already had. And the theme of this World Press Freedom Day, it talks to that reality. The title is Shaping a Future at Peace, Promoting Media Freedom and Human Rights and involvement in an era of all these different turbulences that are taking place. We'll be having this event in Zambia, and I'm happy that Pamela is here from Zambia. The event is going to take place in Lusaka, Zambia, on the 4th of May and the 5th of May. The 4th of May is when we'll have the global plenary, where we'll have different stakeholders, coming and having different discussions. And then the 5th of May is when we'll have different side events, about 25 side events by different actors, organizing small meetings or bigger meetings, medium meetings, talking about different aspects related to this. So 4th and 5th will be of May will be in Lusaka to work on and talk about and create these conversations on this very important topic. And lastly, Chair, if you allow me about 30 seconds. Related to National Human Rights Institutes again, as part of our engagement with the National Human Rights Institutes, we've organized a side event at the Global Alliance of National Human Rights Institutes in Geneva, whose theme is promoting human rights in the digital age, looking at showcasing some of our work that we do in this respect. Please, if you will be in Geneva on the 1st of April is when we're going to have this side event from 13 hours to 14 hours. We welcome all of you. And if you want more information on this, then you can speak to me. I'll still be here. Thanks so much for the opportunity. It's been a little bit short. I would have wanted to speak a little more about other issues, but I know that we usually don't have enough time to say whatever I want to say. Thanks so much.
Thank you very much, John, for being so efficient in putting your points in a very succinct manner. I think we will have about maybe 5 minutes in which if anyone has questions that brief questions that they would like to put to the two speakers who are here with us, to John and to William, we can spend a few minutes on that. Anyone would like to ask something specific about their presentations? Okay. Yeah, William.
Sorry, if I may, spontaneously, a couple of things I would have liked to say, and I'll say them very briefly now. The first is that the Secretary General's strategic plan has some interesting wording about the future and the concept that she has for the next 5 years. She speaks about early warning, monitoring, learning, and doing. I would add to that implementation. These things cry out for substance, is what I'm saying, working with the non-government sector. The second thing is just to mention, and John Bosco may not be fully aware, there is a plan from the CJA, one of them, to implement the principles through work with around elections, free and fair media coverage, the role of the media, safe media during elections, something where the Commonwealth has some form and some expertise. The idea is that there will be, hopefully, with the help of the Secretariat, something rolled out before the end of this year in a country of the Commonwealth having an election. That would be one concrete example of action. Thank you.
Thank you very much, William, for that. Would you like to have a last word, John, on anything, or would you like to add a last line? Or?
Yeah, I could. I think one of the things that I didn't talk about is, as a risk factor, is the issue of conflict, which you mentioned when you are introducing this panel. Conflict since 2022, and it's not that we didn't have conflicts before. If you look at the graph in our monitoring of the killings of journalists, for example, since 1993, you notice that the years, for example, 2011, 2012, 2013, 1993 up to 95, the graph goes up like this, because these are periods that reflected specific conflicts. But since 2022, when the war in Ukraine started, we started recording again a number of journalists that are getting killed in conflict situations, overtaking the number of journalists that have been killed in what you frame as in peaceful circumstances. So, which means that war is a risk factor that is disrupting the normal flow of the news information system and ecosystem, either by journalists getting killed
or journalists getting silenced or being intimidated to cover issues related to the war, or journalists going into exile. And there's a lot of work that is being done on exile media because of the turbulences that are created in those contexts. So that also ties into the key issues that we are going to discuss in the World Press Freedom Day, because one of the key pillars of the discussion in the panel is going to be about media, peace and security. And the issue here we're trying to frame is, when we talk about conflict, we talk about victimhood. So we talk about killings of journalists, attacks against journalists, targeting of journalists. But can we also frame a discussion where we talk about a positive role or some kind of agency of the media or journalism in peace building? So it's sort of backward and forward moving process. So that the discussions will be talking about what can we say about the media and journalism in the peace building process, rather than just talking about victimhood.
Thank you very much, John. And that point that you made about the targeting of journalists is, of course, something that is especially concerning, that journalists have fallen victim to war in the past, but I don't think there's ever been a time where journalists have been specifically targeted in war to such an extent, and that was especially obvious in the conflict in Gaza. I'd lastly say that this whole business of freedom of speech and reporting is so important because it is the oxygen for the civic space, for the civic body, and for a free, healthy polity. And without media freedom, you're cutting off the oxygen. And I think our speakers today have brought that message to us loud and clear. And I would like to thank them all for doing so.
Welcome back, everyone. I'm online now. All right, thank you. We will now move on to our final discussion, where we look to the future of the CFNHRI members and other organizations fulfilling human rights mandates. This session will move us beyond the what to the how, identifying the best practices, peer support mechanisms, and strategic opportunities that will allow our institutions to work productively despite shrinking civic space. I am honored to introduce our facilitator for this session, Dr. David Russell. He wanted me to keep it at one line, but I'm going to do the honors today. Dr. Russell is the Chief Executive of the Northern Ireland Human Rights Commission. He is a deeply respected figure within the Commonwealth human rights community and has extensive experience navigating complex political landscapes, including post-conflict environments. Dr. Russell has been instrumental in strengthening capacity and independence of NHRIs all over the world. Dr. Russell, the floor is now yours.
Thanks very much, Selena. There's no need. We are 7 minutes over for this panel. So James was great for the previous one, and I'm going to be brutal when it comes to this one. So you're welcome to session 3, as Elena said, and the broad focus is on future steps for the CFNHRI. The purpose of the session really, again, is to generate some practical recommendations. I'm hoping we'll have time for discussion at the end of this session, so I'm going to encourage our presenters to keep it as short as they possibly can. I was taken by John, our first speaker, at the start of the day, who set the scene for us in the direction of travel. And he told us that we were starting from a position, if I'm correct, John, where 3% of the globe live in what might be considered open societies. So that figure is dismal. And when we combine it with the downward trend, the concern for us all is self-evident. The increase in restrictions in human rights in the civic space are felt most acutely, as usual, by those who are most vulnerable and marginalised. Supporters of pro-democracy movements, anti-government protests, advocates of progressive economic policies, women, Indigenous peoples, LGBT communities, environment, climate activists, the list goes on. And in addition to that, which has already been mentioned today and somewhat distinct, the impact on professional journalism and press freedom. But also something that hasn't been mentioned, but something I'm acutely aware of, and our colleagues across these islands will know, is in democracies, when we talk about freedom of expression and the rise of populism and the right, there's also a difficult balance to be played for NHRIs in striking the balance, in effect, whenever people want to say and do offensive things, and the issue of deplatforming, etc. So there's a lot going on within the space. And the civic space is shrinking for almost everything in that regard. As rule of law institutions created by states to hold them to account, NHRIs must recognise that these developments are some of the most pressing issues that demand our attention. And we've already heard of the practical consequences. Pamela, for example, very eloquently set out the case in Zambia, where proposed permissive powers are at risk of narrowing NGOs' ability to operate. Then Lorraine, our colleague online from Australia, mentioned the threat posed from insufficient democratic scrutiny and the potential negative consequences of limiting rights, even when those proposals are presented as necessary to combat hate crimes or to protect the public from harm. So in this session, we're asked, therefore, what we might do to resist the risk of regression and to combat this when it actually occurs. And there's three specific questions that our presentations are going to address as they see fit. First of all, what successful NHRI initiatives can be replicated across the Commonwealth? Second, how can we build stronger alliances between Commonwealth NHRIs, civil society, and our wider international partners? And thirdly, what opportunities exist for the Commonwealth NHRI Forum to lead collective advocacy on civic freedoms? And to help this, I'm delighted we have four experts in no particular order. Rowan McKinnon-Guy in person here with us in the room, Senior Associate from the Equality and Human Rights Commission of Great Britain, who will be presenting on the EHRC's new Human Rights Tracker resource as an example of best practice for NHRI monitoring human rights. And Rowan will discuss how the EHRC is using the tool to monitor civic freedoms. Razmeh Farouk, then, Director General, also in person of the Commonwealth Foundation, who will highlight opportunities for collaboration between NHRIs and civil society organisations to promote and protect civic freedoms in the Commonwealth. Rabia Javeri, is that correct? Apologies, in person, Chairperson of the National Commission for Human Rights in Pakistan, who will provide us with perspective on discussions of NHRI resilience and best practice in restrictive environments. Rabia will discuss also the status of civic freedoms in Pakistan, the impact of the Commission's work, and provide some examples of successful approaches and initiatives adopted by the Commission to promote civic freedoms in Pakistan. And then Ulrich Grieshofer, Executive Director of the International Ombudsman's Institute, who joins us online, who's also General Secretary at the head of the International Unit of the Austrian Ombudsman's Board, who's going to draw on her extensive experience at both the IOI and the Ombudsman's Institution to discuss the particular challenges and opportunities for ombudsmen with human rights mandates in the context of narrowing civic space. We have about 30 minutes. Each presentation has between 7 and 10 minutes. I'm going to try and keep everyone to time. I don't know, is the EHRC one ready to go?
Yes.
It is. Over to you, Ron, you're first.
Are you okay if I just say next screen? Yes.
All right, hi everyone. Thank you so much to the event organizers for this opportunity to present our Human Rights Tracker tool. My name is Rowan McKinnon-Guy, and I work with the Equality and Human Rights Commission. The EHRC is only one of the UK's NHRIs, and we have representatives from the other folks here too, so which is really great. It's always nice when we can all get together. So I believe we were asked to present the Human Rights Tracker just in the fact that one of its main functions is really to increase civic engagement with the international human rights system and kind of improve our own human rights monitoring work as an NHRI in that way. I should mention up front that normally this presentation includes a bit of a demo, but I think because we're short on time, I'm just going to plug that you can go visit humanrightstracker.com. If you want to put that into your browser, and you're more than welcome to kind of take a look at the tool while I talk you through it, and also you're more than welcome to follow up with me about any specific questions about the tool once you've had the chance to kind of play around with it yourself. All right, next slide, please. So I'm just going to very briefly explain who we are. Actually, you can bump it through one more slide, please. Thank you. Great. So as I previously stated, we are an NHRI, and as with others, of course, our NHRI status reflects the Paris Principles, but we're also an equality body. So our NHRI and equality remits are a bit different. Our equality remit extends to Great Britain. Our NHRI remit covers only England, Wales, and matters reserved to the UK Parliament. This is an important thing to say up front, because you'll notice when you start playing around with the tracker that we only have assessments of government action against UK and Welsh governments. And that's why, that's kind of because it's within our human rights remit and scope. Next slide, please. So yes, as with many other NHRIs presented today, I'm sure a core part of our kind of international human rights monitoring work includes doing things like, you know, feeding into treaty body examinations, giving evidence to different international mechanisms, trying to improve monitoring and accountability, and of course, trying to kind of bring civil society along and build their capacity as we go in that space. And one of the ways we've really tried to innovate that in recent years is through this tool. The tracker was initially launched in October 2019, and at the time it was kind of one of the first online tools to do something like this. We've since kind of met with and worked with other NHRIs and other organizations who tried to replicate it or do similar things, which is really great. So we're not the only thing out there, but we do kind of have a unique approach. When we launched it, I mean, there was really three main reasons. I mean, and we conducted background research with human rights defenders, with civil society organizations, and the kind of three gaps that we were really trying to fill with this tool is, firstly, that information about human rights, you know, what they are, where they come from, about the international mechanisms, how to engage with them, about new recommendations that are being issued. All of this is found in really fragmented places. I'm sure if any of you have tried to navigate UN websites or other mechanism websites, you know that it can be clunky and difficult to find information. The second big thing was the language. I mean, sometimes the UN language can feel quite technical. We wanted to break it down for all sorts of different kind of rights holders, civil society organizations, grassroots organizations to be able to engage with this stuff. And third, I know the implementation gap has been mentioned by different speakers today. How are we tracking and following up when gaps have been noted by international experts, recommendations have been issued? How are we tracking action against those things? So those were kind of the three key areas that the Human Rights Tracker was really trying to address. Next slide, please. So here's basically a screenshot of the landing page of the Human Rights Tracker. So if you do visit that website I mentioned, which is again humanrightstracker.com, you'll see this landing page. There's three key tools that you access through the landing page, which are up on the slide. So the first one is the recommendation search tool. The second is the cycle tracker. And the third is the government action tracker. So now I'm going to really briefly cover each of these in turn and try to keep my time down as possible, because there's a lot I could say about each. So the first, just to the next slide, please. Thank you. Yeah, thank you. So the first tool is essentially just a searchable database of all the recommendations that have been made to the UK by UN treaty bodies and the UPR. And you can search for recommendations using different thematic tags. And I should mention that things like freedom of assembly and association and different kind of engagement and participation rights are all there as tags that you can search recommendations through. So for instance, you could pull up what the Human Rights Committee said in 2024 to the UK government around protest rights. You could put that in there and it will pop up for you. A really important feature for us when we were developing this was to ensure that we translated recommendations into what we call plain English. So when you click the recommendation, it'll come up in very kind of common words we use all the time. And then you can expand underneath the recommendation to see the original UN text. So it's still there, but we've found that to be really helpful, especially when we're doing engagement with people that don't work in this space all the time. Another really important feature for us, of course, is that there's a Welsh version of all these recommendations as well. Next slide, please. The second function on the tracker is what we call the reporting cycle tracker. So what you'll see when you click through this second function is an overview of where each treaty monitoring process, well, I guess the 7 out of the 9 core UN human rights treaties that the UK has agreed to follow. You'll see a page for each of them there with this great diagram we've designed that kind of tells you what stage the review cycles are at. There's also one for the UPRs, just kind of a bonus. But this has been quite helpful just for keeping people we engage with up to date in real time as dates are changing. I'm sure we've all had to navigate the complexities of the liquidity crisis with UN treaty bodies right now. So sometimes stuff is changing very quickly. And this is the first place we go when we find out dates have changed or things have changed and we've heard from the Secretariat. So this is supposed to enable, you know, civil society engagement if they don't have the resource to always be tracking that down and speaking to the right people. If you click on each of these treaties, you get kind of a bigger page that explains the treaty as well, background on how it's monitored. And that's the page where we highlight any projects we've funded in relation to that treaty monitoring. So we do also, one of the favorite things I've ever been a part of at the Commission is that we do sometimes get to fund civil society research or civil society engagement in examinations. And that's where you'll find all of that information as well, which is really great. Next slide, please. This is the big new feature on the tracker, which I have time, if I have time, I'm going to try to give a little bit more airtime to. So this third function is basically our assessment of Welsh and UK government action. It contains over 200 assessments of action on different topic areas ranging, you know, across the human rights themes. There is a very specific assessment feature on there for political, it's called political and civic participation in there, but that's probably the most relevant one to today's theme. And next slide, please. So we launched this only next year. Previously, our assessment feature really had a less clear and objective scoring approach. And what we've really done under our new methodology is we've tried to drill down really clearly on only assessing government action or inaction, because we were trying to make it a little bit more objective, which means we do an analysis against a new treaty body recommendation. Based on that analysis, we'll assess either all action has been achieved, significant action has been achieved, some action has been achieved, no action has been achieved, or inconsistent action has been achieved, which in the case of our civic participation assessment feature, which I recently mentioned, there's several statuses under there that say inconsistent action. Got it, thank you. So yeah, if you wanna go look through that later today, there's a lot of interesting information in there. I'm gonna skip through the next couple slides because I've just been given the can you go to slide 13, please? No, excellent timekeeping. Excellent timekeeping. It's okay. I expected it. That was a super rushed tour of the Human Rights Tracker. So if you do have any questions about that last feature in particular and the assessments we've done for UK and Welsh government in relation to today's theme, please do get in touch. We'd be really happy to chat through those with you. And also the part that I had to skip through was kind of our process for updating these assessments and kind of how that actually works. And because I know for NHRIs in the room in particular, trying to resource that stuff and keep on top of it can be quite difficult. So again, if you have any interest in talking about that, please do reach out. What's next for the tracker? Well, we're going to continue trying to support capacity building around it and using it for you know, regular trainings with civil society organizations, government departments. We continue to use our action assessments kind of across our work, which I think is, if there's kind of one thing I could take away just kind of in terms of usefulness internally for an NHRI, is that we've done this research for all of these assessments, and we get to actually extract that and use it for other things It's fairly up to date. It's really useful. And, you know, we really hope that civil society organizations and others also use our status assessments in their own communications. And yeah, that's what's next for the tracker. We're currently doing a big update of last year's CESCR review recommendations. So by this summer, hopefully there's a whole brand new update of content. But yeah, that's it for me. That was really rushed and I had to kind of make up the ending, but thank you so much. Thank you.
My sincere apologies to everybody, yourself and everyone who's going to come after. Razmi, you're up next. I'm going to be equally brutal with the time, and if we do have time at the end and we have time left, then I'll come back so people can speak a little bit more about what they were saying. Apologies.
No, it's okay.
Hi, hope everyone's here with me. We're sort of progressing quite rapidly through this. So just to introduce myself, I'm the Director General of the Commonwealth Foundation, and really appreciate you know, human rights organisations in the Commonwealth inviting us to be part of this meeting. One of the reasons why it's so important that we're here is because for the Commonwealth Foundation, one of our 3 strategic priorities is freedom of expression. And we've just been going through a review of our current strategy, and we feel really strongly about maintaining that as one of our strategic impact areas. We recognise, as Alex you know, highlighted already, and I don't want to repeat, how challenging the current civic space is, and how rights are being tested and you know, undermined continuously, and that, you know, it is a constant effort. And the foundation holding freedom of expression as a torchlight or cornerstone to democratic resilience is so important. Our work is cut out, and, you know, we feel the solidarity with all of you here in the room and all of you online. So with, I guess for us, it's really, as I said, kind of, you know, decline in political rights, media freedom and civic space that we're sort of contending with, and just seeing these shifts and how they take place in the legal, political and digital environments. And we realize that, you know, particularly digital technologies and data concentration is reshaping the landscape. And we are struggling to somehow keep abreast of that and what that means. And it requires a certain level of insight and know-how that we're challenged to understand and really raise our game around. And in this, when we reflect on best practices, we are also looking at, you know, not just the tools that we use, but the way in which we engage with civil society, and what are the issues that civil society is bringing to the fore. I was recently in Jamaica. We had a civil society engagement process across the Caribbean, and it was really interesting to learn firsthand how a lot of the rights organizations were contending with this digital space and the challenges that it presents, and how problematic it was becoming for them, even individually and personally. And the fear as well of monitoring and surveillance and how they deal with that. And I think those realities and remembering those realities are really important in terms of the work we do, because sometimes we can get so caught up in all the kind of legislative and policy work that we're trying to do, but how is that translating in terms of realities on the ground? So in light of that, we are looking at how we can strengthen participatory governance, and freedom of expression is like, you know, how do civil society and how do citizens at large within the Commonwealth want to bring their voices to the fore? We consider very carefully like this approach to dialogue, and how do we support and encourage and create a platform for dialogue. And we see that, you know, there's a lot to be done in protecting this trusted space that we have with civil society and that civil society has with each other, including creative actors and policymakers, and really trying to address politically sensitive issues that can be sometimes very complex to articulate in a way that everyone understands and can engage with. We have really tried to think about, you know, what is our role as a trusted interlocutor? How can we build bridges
between government and civil society, and how do we use our convening power and our relationships to bring civil society perspectives into sensitive policy spaces. I was actually in Fiji last month, 6 weeks ago, at the Commonwealth Law Ministers meeting, and it was a really important opportunity with all the attorney generals and ministers of justice present in that space to take forward some of the issues that, human rights organizations are contending with, and to make sure that there's a platform to take up some of the key challenges. But how informed are we? How connected are we in terms of identifying those priority issues and bringing those to the table, and then holding or influencing our governments in terms of holding them accountable to the matters that most affect us in terms of rights. I'm trying to rapidly go through some of the examples and issues, but I'll move on quickly, Alex. One of the other areas that we're really trying to embrace is creative advocacy and support to creative actors. We see that, it's really important that there's a pathway for expression that allows us to sort of somehow address sensitive political issues, but in an open way, but in a non-traditional way, using non-traditional advocacy. And free and creative expression, we feel, can be a really powerful tool, because in many contexts, culture is a lifeline, and understanding people's cultures and really grounding it in the context that they work in and what is important to them, and how their creatives and how their creative expression brings that to the fore, can be extremely powerful and door opening. So we work quite closely with creative practitioners in advocacy spaces and encourage integrative creative approaches in civic engagement. We feel that, sometimes even, the music, rap, the lyrics, the poetry, the performance art can take, and people, citizens at large, really take seriously, probably more popular means of communicating issues, and then can mobilize to take those issues forward. And that work that happens at the ground, mobilizing through a cultural lens, is really significant in promoting the work that you're all trying to do in your various spaces. Finally, we do have a great grants program. It's not big, but it is really focused on promoting work in the areas that we prioritize, freedom of expression being one of them. And we really try to make our funding flexible and responsive, and really reaching out to grassroots organizations who are doing critical work, for which our funding is a lifeline. We see that it's important that we invest in capacity building and invest in technical support and tools, as well as really creating those bridge building opportunities. Without one, there is no other. So it's about how we invest in the ecosystem. And it's not even just the ecosystem for civil society, it's the ecosystem for creatives and creative organizations. So we see, there's a lot of work that is important in terms of our grant making, and our niche funding and ideology is really pivotal in the context we work in across the Commonwealth. And I've really sensed that. I've only been in the role for 6 months, but when I've traveled, I've met with some of the organizations that we funded, and they do really powerful frontline work, and they really appreciate the solidarity and support, and the sort of the less constraining bureaucratic systems by which we support them as well to do this difficult work. So just really briefly, those are sort of some of the key reflections from our end, appreciating that we are a multilateral organization mandated to work with civil society, and can hold some really important space and carry that responsibility with great pride and consideration. Thank you.
Thank you.
Thank you very much, and thank you for keeping the time. And even in that little short presentation there, condensed, there's at least one question I would like to ask, but I'll hold off for the moment. Ravia.
Give me her time. You can give me her time.
The floor is yours.
Thank you. Bismillahirrahmanirrahim. Thank you very much for the opportunity to be here. If you could kindly, Rachel, if you could kindly open the presentation, because I can't see. I forgot my glasses. Can you imagine you travel and you forget the most important thing that you have to do. So 1 minute, I've lost it on my phone. Sorry, guys. So anyway, when we talk about civic space, I think it's very important to talk about what civic space is. So I'm going to talk to you about physical civic space and digital civic space. And again, I'm going to talk about those communities that are most impacted by that, by accessing that civil space, which is women, persons with disabilities, transgender person. I'm going to focus on women. I'm going to give you 3 stories of physical space, digital space, the problem that women have had in that space, what we have done to address that problem, and some innovative ways in which we've tried to create a positive change in the way the government sees it, in the way people can address the commission. So the first thing is, next slide, please, Rachel. Digital space. Pakistan has a very, very difficult record because we have gender inequality in the digital arena. We have a large number of gender harassment cases in the digital world. I myself have been a victim of terrible trolling. When you're trolled as a woman, you are so horribly exposed, your family, your children, and so on and so forth. And it's an invisible enemy you really can't cope with. In terms of physical access, we have the problem of a gender gap index, we have segregation, we have harassment, and we have the weaponization of religion, the extreme marginalization of women, limited access to public space. Next slide. This is the slide of one of the most eminent Pakistani journalists, Asma Shirazi, who was trolled for several years, and how she coped with it. Because I'm in a rush, I'm going to just do a little bit of her. If you could press the video, her telling her story
हम
of
सिर्फ
what it was
औरतें
like.
नहीं होती, हमारे साथ हमारे मर्द होते हैं, हमारे ख़ानदान होते हैं, हमारी ऐसी ऐसी गंदी नंगी तस्वीरें बना के भेजी जाती हैं कि आप तसव्वुर भी नहीं कर सकते. अगर आज भी मैं कभी अपने ट्विटर की वो नीचे खोल दूँ ना, तो आप गालियाँ पढ़ के समझ जाइएगा कि और मैं अब बंद किया है, बहुत से अपने बच्चों की वजह से बंद किया है, मेरे बेटों की वजह से. तो मैं कई बार सोचा कि मैं छोड़ दूँ.
So what she said, that sometimes I thought, which is what women do, how do you self-censor? You just stop your association with telling the truth to power. You stop speaking because you're so scared of the impact on your children, on your families. Now deep fakes are coming out, all kinds of horrible things. So the story of Asma was a years-long fight of trying to get, to bring her position to the government, to try and address this. Now, the next slide. In Pakistan, 150 journalists gathered together before the Standing Committee of the Senate. I was a part of it, and they presented a petition to the government of Pakistan saying, help us. As women, we cannot do our job if we are going to be exposed to this kind of harassment. What do we do? 50% of Pakistani women in Pakistan do face stalking harassment. 60% of women journalists have refrained from doing work. They self-censor. 70% of Pakistani women fear deep fakes. They fear this kind of photos being manipulated, changes. This also trips down to students, young women who have committed suicide for these sort of deep fakes. Next. Now, in this environment that you see this, one of the most prestigious journalists of Pakistan facing this kind of abuse, what's the problem? What's the ecosystem, the atmosphere? The atmosphere is a very, very defective law. Laws that give a lot of leeway for the state to either catch you for, if you're a journalist, under very, very loose definitions of what is what they call it, the word they use is aspersion. So it's a very wide definition, and you can catch journalists for aspersions against state, against politicians, against military institutions. So the law is very, very weak. The complaint mechanism is a very male-oriented, a patriarchal system in which people fear going ahead. to talk about something that's very deep or emotional or sexual? How do they go? There's a lack of awareness of the system in the digital area. How do you move forward? What does the law give you? What are the rights they give you? What are the remedies they give you? And then this deep entrenched patriarchy in Pakistan, which prevents women. I mean, in Pakistan, women, only 46% of women report rape. 18% reach level of prosecution, and the conviction is 0.3%. So the level of attrition that women face when they go to report crimes against themselves, whether it be physical or digital, is the low level of conviction is a big deterrent. Next, what did NCHR do? So the first thing was we did a legal review. We talked to the government about, hey, what are you guys doing? The law is defective. The law needs to be fixed. We had consultations with law, with parliamentarians, telling them about our concerns with the law. The second thing we did was we went to visit the complaint system. We acted as if we were victims. We went to visit the centers and we tried to find out how difficult it is. 12% women in Pakistan on the police force. How do you talk about issues that are sexual related or deeply violence based? This was part of our report that we did. The third thing was creating awareness on what are your rights and remedies, and then trying to empower women by telling them that you have to get out of the system of patriarchy. You have to training them, capacity building. We also did interesting things that we set up our own help center for women journalists in the commission. We pushed these 150 women that went to parliament. We were lobbying and leading them to go to the standing committees and talk about that problem. We did a hackathon in which we used young students to create AI technological solutions to access to justice. How do we have the Chief Justice involved in this? On how do people use apps to complain on this? We did an interesting thing also. In a particular incident of violence, we developed algorithms. We started tracing out algorithms, and through the algorithms, we identified hate words, particular words that were key or hot words, and we use them in an incident to prevent a scale of mass violence. We also used it in an incident which had already happened, but we were able to prevent it because we were able to source out words that were hot, words that were able to talk about hate speech, or we thought could lead to a possible issue of violence. Okay, next thing. So if you go to the next slide, just quick, Rachel, this is, if we could just go through the next ones. These are reports. Next, these are campaigns. These are letters we've written to the government. Next, these are consultations with 100 women journalists. Next, this is our work with Asma. Now, the next video is one of the most powerful videos, but I will let it go. This is about physical. Next one. I'll let the video go because I think, but it's a good video to keep. Next one. This is about a march that women do every 8th of March called Aurat March, which is Women's March. And the logo they do is Mere Jism Meri Marzi, which is my body, my right. And this was very badly used by the right wing to imply that it was pornographic, that it was women who were trying to claim their bodies, it was sexual, it was blasphemous. These women were targeted, they were, right-wing people boycotted this. So what did we do? The commission, next. So the commission, we were able to lead the march. We were able to ensure that they were not arrested. And some that were arrested, we were able to get them released. We were able to make public statements, open letter to the government on talking about their rights and their right to claim public space. We've totally resolved in our commission 8,000 complaints. We have powers of sumo moto. We have taken 173 sumo moto cases, 50 plus reports and investigations. We have also been spearheading the transgender rights. We've helped draft the transgender law, which is now law. Many countries are deciding whether they have a third bathroom. We've got a law, we have a third column in our legal passport, ID card, so on and so forth. And a funny, interesting thing that we did in terms of, besides capacity building and training, we went to the village elders of one of the most remote communities in Pakistan, and we asked permission for the girls to do football. And through support from actually the Canadian CFLI program, we trained them in a very male, in Pakistan it's considered male sport, and we're able to get these young girls. It's now, our program, which started off with 150 girls, is now rolling, girls are involved. And that was our way of saying, let's take physical space, let's take control of our physical space through sports. So you can put the last one on for 20 seconds. And when these girls came in, they said to us, we found peace at last. So we can end with that if we can. Not the next slide. Next one. If you just play this.
मेरा नाम निकी है और मैं हज़ारा वुमेन यूनाइटेड के प्लेयर हूँ। जो हम फुटबॉल करते हैं ना, हमारे अंदर जो है एक फीलिंग, एक पीस है, एक ख्याल है जो हम लोग मतलब बहुत शौक से करते हैं, बहुत दिल से करते हैं।
So this is now one of the most popular programs. Women are coming, and little girls as old as 8 and 7 years are becoming football players in North Pakistan. Thank you very much. Thank you. God, you had me under pressure.
I'm a hard task.
Really?
And finally, last but not least, we're going to go online, and we're joined by Ulrike, who's going to present from the Austrian Ombudsman. So over to you. I'll be equally strict with our online participants as well, but the floor is yours.
Thank you very much. Thanks a lot to the Commonwealth Forum and the Samoa Office of the Ombudsman for organizing this meeting and for this opportunity to engage with all of you. It has been a very enriching afternoon already, and I know it's been a long afternoon as well, but I'm happy to present 2 more perspectives from the 2 institutions that I work for. And those are the Austrian Ombudsman Board and the International Ombudsman Institute. So if you go to the next slide. So because of the time restrictions, I will go pretty fast. I'll try my best. Yeah, so next slide, please. Okay, not coming. Yeah, perfect. Yeah, we can go to the next one directly. So first, I would like to speak about the Austrian Ombudsman Board. It is a classic ombudsman institution investigating in maladministration. We receive, like last year, we received 23,000 individual complaints, which is quite a lot. We also can do own initiative investigations, but we have quite a lot of other mandates as well. One important one is obviously that we are also the NHRI of Austria. We are A accredited with GUNRI. So we have a very broad human rights mandate to protect and promote human rights. We are also, since 2012, the national preventive mechanism and can therefore monitor all places of deprivation of liberty. We also have a mandate as monitoring body under the UN CRPD. Yes, and then if you go to the next slide, just quickly with regard to our organization, we have 3 ombudsmen who divide the work among them. They are elected by parliament for 6 years. 1 re-election of another 6-year term is possible. They are guaranteed by the Constitution. They are independent, impartial, irremovable, and are therefore quite a strong institution. Next slide, please. We have about 90 staff at the Ombudsman Board. We have additionally, especially to accommodate our human rights mandate and the NPM mandate, we have 7 monitoring commissions staffed with experts from various fields. So they are not staff members, but they are working on an ad hoc basis for us, and especially doing the visits to all the facilities where people are deprived of their liberty. And additionally, we have a Human Rights Advisory Council I will touch upon that a bit later, but this is basically the setup of our institution. Next slide, please. Yes, so we're talking about the shrinking civic space. So what does it look like in Austria? As could be seen on the map that Andrew Furman showed at the very beginning today, if you looked really closely, since Austria is very small, you could see that Austria is still considered a country where we have an open space. So it was actually properly green. And I can also support this this assessment because freedom of expression, assembly, etc., are observed, and no detention of journalists or human rights defenders were reported in the last year. So we are actually in a safe haven, I can say, especially compared to, unfortunately, a lot of our other speakers and friends around the world. But I would like to focus on civil society in Austria, as one of the leading questions of this panel is how can NHRI, ombuds, and public defenders build stronger alliances with civil society and international partners. So in Austria, there are quite a lot of civil society organizations. They are well organized. There are also various umbrella organizations who coordinate their activities and cooperate. So, for example, 300 CSOs submitted a joint shadow report for the UPR of Austria. They also coordinate their media work. So this is quite a strong quite a strong community, I would say. On a yearly basis, the government actually organizes a plenary session together with government representatives and the civil society organizations. The Austrian Ombudsman Board, as NHRI, is also part of this. And the idea is basically to have a structured dialogue between the government and CSO, mainly preparing the UPR and to follow up on the implementations of the recommendations. Next one, please. But we do have challenges. As I said before, the civil society organizations can still operate quite freely, but over the last year, actually, we've seen that that there is also shrinking space in Austria, and challenges have appeared. Especially, for example, one opposition party started framing CSOs that they were wasting tax money. So whether they were using some parliamentary control mechanisms to create a negative narrative about CSOs. And that also resulted, among some other things, resulted in a demand for an CSO transparency register, which should list all the donations that CSOs receive and to avoid foreign influence. This practice could potentially resemble foreign agent laws that aim to prevent cross-border cooperation of CSOs, and is therefore looked at with a rather negative impact as well. But most strikingly, maybe in Austria, we can see, as also is the case with many organizations, I think, around the world, is that Austria has had to have some austerity measures and severe budget cuts, and that also leads to budget cuts for the civil society organizations. And some of them have already warned about the effects that this will have, especially in the migration and integration field. So this is what we can report in Austria about the shrinking space at the moment. But what can we as ombuds or NHRI do to support civil society? So how can we build these stronger alliances? So we came up with some practices of the Austrian Ombudsman Board, how we interact. So we started a few years ago to hold NGO sounding boards. That's what we call it. It's an informal quarterly meeting where NGOs from various human rights fields covering the variety of Austrian society convene to have an exchange on current human rights issues. the CSOs have the possibility to bring forward some complaints from individuals to the Austrian Ombudsman Board. And on the other side, the AOB can also encourage CSOs to
You have
send
1
those
minute.
individuals. Oh,
1 minute.
okay. Okay, I'll be very quick now. Then, yeah, next slide. We also do an NGO forum once a year where we engage NGOs with a broad variety of actors and discuss human rights topics. Next slide. We have developed a UPR tool quite similar to the human rights tracker that we heard of before. Next slide. On a more institutionalized level, we work together with the Human Rights Advisory Council that consists of half of the members are government representatives, the other half civil society organizations. And this is an institutionalized, based in the Constitution of Austria, institutionalized cooperation between Austrian Ombudsman Board and civil society organizations. All right, if I only have that short amount of time, I'll quickly go to the IOI, my second organization I work for. Yes, you can go through this. I'm happy to share this the slides afterwards, so you can take a closer look and come back with any questions. I would just like to mention on the next slide 2 main topics who I think, well, one back, please. Sorry, one slide back. This one, yes. So I just would like to highlight 2 of the activities of the IOI with a focus on the civic space, and those are the regional subsidy program. This is one of our flagship programs where we finance projects of our members, ideally with a regional impact. There's once a year a tender since 2010 actually, and we seek to support capacity building. Just this last year, we had among the recipients were actually Samoa Ombudsman Office for police training, or the Ombudsman of Punjab for their mobile van to do outreach in the vaster regions. So that's really a tool where we as an organization can help our member institutions to implement projects that have a big impact on civil society. And the second one I wanted to talk about is the last one here on the list, is Ombudsman Under Threat, because we as ombuds institutions, as NHRIs, we are also human rights defenders, and we are also under threat, unfortunately, or could be under threat. This has various forms: governments limiting budgets, reducing budgets, but increasing our mandates. So in effect, we cannot fulfill all our tasks anymore. But also sometimes if ombuds institutions are not allowed to table their reports at Parliament, for example, is also already considered as being under threat and limiting the independence of the institution. And there the IOI tries to help as much as possible. We have developed IOI guidelines for ombuds institutions under threat. So whenever you feel like you have a problem, you can come to us, and then we look together for the best way how we can support you, be it writing letters. This can go up to having a fact-finding mission in the country. So we really do quite a lot. And then, yeah, in the slides, you will see just some examples of what members have done, but my time is up. So basically, I would just like to thank you and just mention that, considering the current developments around the world and the backsliding of democracy, limitations of our civic space, etc., it all sounds quite daunting, and one could easily lose hope. But we also heard positive examples today, and I think the essence of meetings like this is that we learn from each other and encourage each other to work together and seek energies and seek partners to have a stronger voice for the voiceless. Thank you very much.
Thank you.
Thank you, Rick. Thank you, and apologies again to everybody. The reason why I've been so hard on time is because we're actually going to lose the space. for those that are online. So that's the reason why we've had to cut them short. We don't have time actually to open it up to discussion, so I'm told, because we're going to lose it. But very, very briefly, just to summarize some of the things we've heard, it's surprising, even though you've had very little time each as individuals. Like, I actually took quite a lot from what was said there. I mean, Rowan addressed the importance of data. In essence, the NHRIs operating in this space. Evidence-based accountability is critical to operating within the space. In a period when misinformation and disinformation in particular is so rife. I mean, this really threatens to drown out legitimate voices that operate in the area of civic space. And the EHRC tracker is a really great demonstration of how we might deal with this in practice. Razmi from the Commonwealth Foundation has highlighted the opportunities to increase participation and dialogue as a pathway for freedom of expression. I said, I'm sure Michael, who's accompanying me today, his eyes would have lit up at the idea of culture and arts, not least because as an NHRI, we're just about to embark ourselves in establishing an arts forum, partly to open up more civic space for more variety of voices in our work. So I'd love to pick that up afterwards with you in particular. Rabea provided just very solid practical examples of the need for space, particularly for women and girls who are too often denied opportunities because of digital technology, utilized to victimize and then re-victimize people and stymie freedom of expression. And the NHRI example in particular from Pakistan in terms of advocating for a comprehensive approach, law reform, combined with addressing the complaint system, combined with ensuring the NHRI itself is accessible for victims. And crucially, I think, and we know this from ourselves again in Northern Ireland, demonstrating solidarity in the public space with those who are most vulnerable. And then finally from Austria, the role of a multi-mandated institution is absolutely critical and quite unique. We don't all have the same level of complexity that the ombudsman's bodies have, particularly when we're commissions, but so much in terms of maladministration as well as the NHRI function. And that practical example, again, of building a relationship around the Universal Periodic Review within the shrinking space when the negative narratives that you were talking about towards the end there and the demands for registration, which has been mentioned on a few occasions today around foreign agent laws, combined with budget cuts, is probably something that resonates with a whole pile of us. So thank you very much for participants, and apologies that it was so short. Thank you.
Closing remarks from the chair of the CFNHRI and acting ombudsman of our office.
Can we have another round of applause for our last panel session today? And thank you very much to Ellen, Lena, and Rachel for our very interesting day today. Colleagues, as we come to the end of today's high-level dialogue, I want to thank each and every one of you for the depth, honesty, and generosity you've brought to our discussion. It has been a very, very full afternoon, but it has also been a very rich one. And the quality of the exchanges reflects the seriousness of the moment that we are all in the space that we're trying to navigate. And do apologize for the very short and last minute session, but we have taken away a lot to think about today. And across every panel, a consistent message has emerged. Civic space is narrowing across the Commonwealth. And this has direct implications for our ability as NHRIs, ombudsmen, and public defenders to fulfill our human rights mandates. So we've heard about restrictive laws, regulatory barriers, digital surveillance, pressures on civil society, and the very real threats facing journalists and media workers. These are not abstract trends, and they shape the daily realities of our institutions and the communities that we serve. At the same time, today has highlighted something equally important: the resilience, innovation, and principled leadership that exists across our network. We've heard examples of NHRIs navigating very complex political environments, building new tools for monitoring human rights, strengthening partnerships with civil societies, and finding creative ways to protect freedoms even when space is tight. These contributions remind us today that while challenges are significant, they're not insurmountable. And drawing on these insights, we have prepared a very short draft CFNHRI statement on civic freedoms. And the statement reflects the themes you've all raised today: the legal and regulatory pressures, the digital dimension of civic space, the centrality of media freedoms, and the need for a stronger collaboration across our institutions. And it also sets out the commitments that we, as a forum, are prepared to make as we move forward. So given the time and the richness of today's discussions, I will walk through the statement with you very, very briefly on the key elements. Then I'll invite you over the coming days to provide some written inputs. And this will allow everyone the space to reflect and ensure that the final version on the screen truly captures the diversity of the perspectives across our forum. So briefly, the outline of our statement. It begins by acknowledging the current pressures on civic space across the Commonwealth. It then highlights the legal, digital, and media-related challenges we discussed today. It sets out a series of commitments for CFNHRI members, from strengthening monitoring and reporting to advocating for enabling legal frameworks to supporting media freedom and digital rights. Finally, it includes a call to government to uphold civic freedoms, protect journalists and human rights defenders, and engage meaningfully with NHRIs. I would have loved to open the floor for high-level reflections, but in the interest of time, we will circulate the draft statement after this dialogue and invite your written input. Your feedback will be consolidated ahead of our engagement in Geneva next week, where we will continue with the consultation process before we take the statement to Antigua for formal adoption in November. This statement will only have an impact if it reflects our shared voice. So today's discussions have moved us firmly in that direction. And I thank you again for your commitment. I thank you for your expertise and your partnership. It has been a privilege to share this dialogue with you all. And I look forward to continue working with you in your future. Faftaitele for the point at the officer. Elisi de la Vatsa in a out of one. So for my Emanuel. Thank you so much.